call these.
Good morning. This is the New York City Board of Standards and Appeals public hearing for September 23rd, 2014. We'll begin with the special order calendar decision items. Item number 1, 99784BZ, 798 Union Street, Brooklyn.
Motion to grant.
Chair Perlmutter?
Yes.
Vice Chair Hinkson?
Aye.
Commissioner Montanez? Aye. Commissioner Otley Brown?
Aye.
Thank you. Thank you, Madam Chair and Commissioners.
Item number 2, 19312BZ, 384 Lafayette Street, Manhattan.
For a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez? Aye. Commissioner Otley Brown?
Aye.
New cases. Item number 3, 69859BZ, 2773 Nostrand Avenue, Brooklyn. The office of Eric Palatnik.
Hello, good morning, Eric Palatnik. We attended your review session yesterday and we heard your board's questions regarding the remediation system that's in place on the property, as well as your request to provide more information on the circulation plan and the parking layout and the distance from the curb cuts for the pedestrian access on the sidewalks, I assume. To answer some of your questions, we'll get you more information. The remediation system that's in place was discovered. There was a leak discovered when they replaced the tanks. I don't know the exact number of years ago, but it was a few years ago. And they were replacing outdated tanks with new modern tanks, double-walled fiberglass tanks, which are the recently new requirement. When those were installed, there was a leak discovered. It fell under the jurisdiction of DEC. There was a remedial action plan set in place, and the equipment that you see on the property is pursuant to that remedial action plan. So we'll get you more information. We don't believe it makes any noise. We spoke with the engineer. I believe it's a relatively quiet system. We don't know of any complaints. Maybe somebody might be here today, but we haven't heard of any complaints. The matter was approved at the community board, and there were no complaints lodged at the community board. But we will get you more information on it.
Including how long the remediation must continue?
Sure.
And with respect to the trash, there was a question about the potential relocation of the trash to the other side of the property away from the residential building.
I wasn't aware of that question, but I'm sure that wouldn't be a problem.
And then the other is about improving the separation along the residential property line with plantings, because the plantings are sort of this scattered, sad hedges, but to make something that's really more opaque, like a thick privet that goes all the way across.
We'd be happy to do that.
Any other comments?
And you'll do the, I'm sorry, you may have said this and I didn't hear you, but you'll do a site plan showing the circulation?
Yes, I spoke to the engineer, and we'll create for the next submission, we'll create a circulation plan to show you the movement of vehicles.
On the site and how that,
yes.
Okay, great.
And how it all interplays, yes.
And did you say what the hours of the store?
It's
and
24.
They're both going to be 24/7? Okay.
Is there anything else?
No, that's all.
Are there any speakers on this item? Okay, how much time do you need?
We could submit within a matter of weeks, whatever's comfortable for the board schedule.
Okay, so if you could submit on, well, so November 5th for a hearing on the 18th.
Thank you.
Item number 4, 90279BZ, 1096, 1097, 79BZ, 14803BZ, 111, 113 West 28th Street, and 116, 18, 120, 114 West 29th Street, Manhattan, the firm of Goldman Harris.
Good morning, Commissioners. This is an application to reopen and amend 4 separate variances that were previously approved by the board. It involves 3 buildings on West 29th Street, which are in common ownership, single ownership, but they were approved with separate variance applications. And then there's 1 lot on West 28th Street, which was previously approved for variance, and that's a condominium ownership at this time. Why don't we start with that? Why don't we get get grounded on this.
Take the mic with you, Howard.
Thank you. It looks confusing, but it's not. Bear with me. 6th Avenue, 7th Avenue, West 28th Street, West 29th Street. There is a proposed new hotel on this site, which is lots 30, 31, and 32, 3 lots. That is an as-of-right hotel. It doesn't seek any variances. It doesn't seek any waivers. It's completely as-of-right. However, the hotel seeks to transfer unused development rights from, as I said, 4 properties. This property on West 28th Street, which is improved with a 7-story building that was converted to partial residential use pursuant to a variance in 2003. And then these 3 buildings on a single tax lot, Lot 49 on West 29th Street, which were also converted pursuant to BSA variance, but back in 1979. Okay, so these guys were converted in 79, and this guy was converted in 2003, and this is a proposed hotel site. Okay. So why are we here if the hotel is as of right? We're here because all of the prior variances have to be reopened and amended in order to allow the zoning lot merger to take place with the hotel site and with the other lots. Because if you open those variances up and you look at the zoning lot, you will see just those properties. And this will be an enlargement of the subject zoning lot. So that has to be reflected on the prior variances. And in addition, pursuant to the merger, there will be a transfer of unused floor area from the lots that were previously approved by the board. So that's what we're doing with this application. We're seeking the board's approval to reopen and amend the previously approved variances.
Just a question there. So the application, though there are 4 different variances for arguably 2 different sets of properties, I didn't see that you submitted 4 different applications. So
We did.
That's what's very confusing.
No, we did. We submitted 4 separate applications.
You did.
One for each building on 29th Street, 1, 2, 3, and one for the West 28th Street property. That's number 4. And that's why there's so much paper, because there are 4 separate applications that are to a large extent duplicative. But we submitted a separate application for each building.
Now, the lots that are encompassing the hotel.
Yes.
None of those were part of the previous
Correct.
variance?
Absolutely right.
Right, so it's just those outside of the hotel?
Correct.
Okay, just want to make it clear.
So the reason this application is being brought in the form that it's being brought, it really relates to a court decision. This isn't a variance case which involves hardship findings for the hotel. It's not a special permit which involves specific findings that are in the zoning resolution. This application is being brought because of a 1997 New York State Court of Appeals case called the Bella Vista case. And that case basically involved some, how should I put it, deception's too strong a word, but some lack of full disclosure to the BSA with respect to an application. What happened was, this was in Bayside, Queens, and the same owner owned 2 adjacent properties, fairly large properties. The owner applied for a use variance for one of those 2 properties to build a movie theater in a residential district. So it was a use variance. The owner did not disclose, did not tell the board that it owned the adjacent property. It was not made part of the record. So the board approved the use variance for the movie theater, and then 3 years later, the same owner transferred or tried to transfer all of the unused development rights from the movie theater lot to his adjacent lot for the development of an as-of-right residential building. And DOB, and he tried to do it on an as-of-right basis, and DOB said no. You have to go back to the board because the transferor lot is subject to a variance. And an A case was brought, and the board upheld the Department of Buildings. And then the matter went into the court system, and you know the Supreme Court and the Appellate Division upheld the applicant. But when it got to the Court of Appeals, the Court of Appeals sided with the Buildings Department and with the BSA, and basically said, this merger and this transfer cannot take place unless there's review by the BSA of the application. And specifically, the issue was by not disclosing the joint ownership of the properties was the BSA's or the B and E findings somehow tainted or inadequate or wrong because you had a large store of development rights that were worth a lot of money and that were readily under the control of the applicant and not disclosed to the board. So if the board had known that, it would have taken the value of those unused development rights and factored it into the financial findings for the variance. So pursuant to the Bella Vista case, the rule now is that that development projects that seek to merge with properties that previously received variance are subject to board review. And the scope of the board's review is to determine that the prior financial analysis done for the property that received the variance was not improper, that it didn't leave out the value of the development rights. That's the issue. It's a narrow scope. The new building is not reviewed. The waivers are not reviewed. The sole question for the board is whether at the time the prior variance or variance were granted, did the board properly take into account any unused development rights. So that's what this application is all about. And in this case, we think the board's previous approvals were 100% on point because our basic point is that the development rights at the time the previous variances were approved, once again, 1979 and 2003, those unused development rights did not have any kind of significant market value at that time. And that now, 35 years after West 29th Street and 11 years after the West 28th Street variances, they do have value, but those values are attributable to changes in market conditions since the date of approval, changes in the economy, basically changes in West Chelsea that have now given these particular development rights value. But at the time of the grant, it was completely reasonable and proper for the board to conclude that the development rights did not have a value that should have been factored into the B and the E findings. And what we've done in our papers is we've addressed, each of the transferor lots and looked at what the conditions were at the time of the variance. So what were the possible transfer sites? Where could the unused development rights have gone at the time those variances were granted? And in 1979, we looked at the adjacent properties, and which would be on West 29th Street. We looked at Lot 44, which is to the east, and we concluded that it was almost 12 FAR. It was overbuilt, couldn't go there. We looked at the adjacent lot on 53rd Street, and I apologize, this board, there should be one for each site, or at least for each street. This board focuses on 28th Street, and the reason it focuses on 28th Street is because that's the newer variance. We don't think the 79 variances present major issues because it was so long ago. So we've really focused more on the more recent variance, which is the 2003 variance on 28th Street. But in any event, this small property on 29th was not a viable receiving site. It's 25-footer. And we did the same thing on 28th Street. This is the site that received the prior variance, and this is a 21-foot lot over here. This is a 21-foot lot over here. There were no assemblages at that time. This lot was not part of an assemblage, so it would have been a logical receiving site for the development rights. This lot at that time was not part of an assemblage that would have made it a good receiving site. This lot was overbuilt, forget it. This lot was not part of an assemblage. So the conclusion, which is supported by the Freeman-Fraser analysis in your packages, as well as a separate independent study that was done by Landauer, appraisers for the 28th Street site. All of those studies conclude that as of the relevant approval date, the unused floor area did not have a financial value, thereby invalidating the board's approvals back in those days, if you now allow the merger and transfer of those air rights.
So you said that the site to the, the east, the site to the east, the pink site to the east of the 28th Street, was not part of an assemblage. How did you determine, and with what materials did you supply to determine that it was not part?
We pulled all the deeds, we went through each of the deeds, and determined there was no common ownership at that time. We also looked at the DOB records to see if there were applications affecting more than one lot, and there weren't any.
Did you submit those materials?
Yes, we did. I believe we did.
When you said you pulled the deeds, did you look behind the ownership? I'm assuming they're all owned by LLCs, so you actually can't figure out who the owners are.
We did not look behind the nominal ownership. I'm not sure I know how to do that, but.
You go to the State Department website, and then you see what the address is for notification, and often assemblages reveal, because the addresses are all the same.
Yeah.
So please do that.
Sure.
Particularly with respect to the development site for the hotel.
Yeah,
okay?
what I'd like to do is just sort of, there's so much paper here. Maybe we could pull that all together and just address the potential for assemblage or transfer in 2003 and in 1979 and put it in one neat little package.
Okay. And then, so with respect to whether a transfer was possible and whether an assemblage might have been in the works and so on, there were hotels that were either constructed or in development in some stage in 2003.
Right.
And in Freeman-Fraser's report, there's a statement that those other hotels are irrelevant, and I'd like some comment on that. And also, There's also some discussion about the market in the Landauer report, about the hotel market, and why at that time there would not have been considered value. But if we just talk about some of the projects that were in the pipeline, sort of, I understand that some received permits in, like, say, 2005 or 2006, but as we all know, it takes a long time before you actually receive a permit. So when were those applications filed? That would imply ready to go, ready to build a hotel, maybe even 2 or 3 years ago, which would further refute the argument that there wasn't a hotel market.
Sure. I mean, we have compiled some of that information. We track the date of issuance of new building permits on this block by the Buildings Department. And we found that the first one, the first NB application was filed in 2005. The application was filed in 2005, which was, a full 2 years after the variance on West 28th Street was approved.
Those were you looked at all of the hotels that were in the pipeline, and the first one that had an application filed was in 2005. 2005.
There was and then there were 2 more in 2006, and then finally there's one that's currently under construction that was filed in 2012.
Yeah. Are there other comments, questions?
I just had one question. How then does this affect the previous grant on the the buildings that you're not going to put floor area into? How are you giving up that grant for those sites, or I'm not sure how that would actually work?
You mean the transferor sites, the variance sites?
Yeah, how then do those variance sites
technically
still exist in their variance?
Yeah, the variance remains in effect. We will substitute a new site plan for each of those applications, which will show the enlarged zoning lot. I'm not quite sure how we're going to reflect the conveyance of the floor area. I think we need to discuss that with staff, how that would get reflected in those applications.
But ultimately, the argument is that the condition of those buildings doesn't really change because there was no value then, and by transferring the air rights today, there still would be no value.
Correct.
Okay.
Right. Those variances remain 100% in effect.
I think it's also, actually, there was a statement from one of Mr. Sinclair, the condo president, which did talk about the condition of their building, that was the one on 28th Street. Their building, since the variance was granted, that they've been struggling with the commercial uses and so on. I think, part of the problem is that in terms of the comprehensibility of the application, is there are all of these pieces, and they're not pulled together into the statement of facts. So we're sort of in a place of having to construct the argument for you, which isn't actually what we're supposed to do. So if you could pull those things together, and then, because part of the issue is, have any circumstances changed that might modify the opinion about the variance? And I think that supporting material about sort of the building is still struggling despite the variance helps to offset any concerns about potential value of the development rights in 2003. For instance, they could have been, for example, people could have been warehousing the development rights, that kind of thing. And so maybe there was a market if you had marketed for those development rights. So, you know what I mean? And maybe they would have paid a lower price for them than today.
Well, it just so happens that Mr. Sinclair is here. I'm sure he'd be happy to explain what happened back in 2003. You know, the question is not whether it was ever foreseeable that these development rights would have a value. The question is, at that time, when the application was before the board, was it reasonable to ascribe a value to those development rights or not? It's like a snapshot from that particular time. And, you know, since 2003, a couple of things happened. West Chelsea Special District got adopted, and the High Line opened up. So, you know, boom, the world changed dramatically. But in 2003, neither of those facts had yet occurred.
But again, there was a hotel on the block or in the area already built, or more than one hotel already built, apparently, according to information provided in the materials.
Well, there's a big difference between the area and the block. I mean, a lot of things can happen on avenue sites, you know, better situated sites within a larger area. But this particular block, these are basically mid-block sites, and they're located on a block, 28th Street in particular. That was the former flower market, as many of us remember. And it was in big trouble at the time this variance was approved. It was struggling, and businesses were going down, and the flower industry was moving. So it was not a hot block. It was not a, you know, a hot development area. You know, it was somewhat of a depressed block. And then all of a sudden, now we have this will be the 5th hotel on that one block. But, you know, our point is that all of those economic changes occurred after the 2003 variance.
It might be helpful to also discuss the state of the hotel market in that period after 9/11 in the city and also in that area of Manhattan as well. Because I assume there was, and I think I recollect, a big fall-off in demand for hotel rooms. And so that added to the information you have can also prove that there was not a market at that time for hotel development rights. So you might want to add that to the application.
We'd be happy to do that.
And also, the community board noted 3 hotels in the area built between 2001 and 2003. And they recommended disapproval of this amendment for West 28th Street on that basis.
Yes. One of the reasons the application seems to be here and there and here and there. So we spent a lot of time with the community board developing, you know, writing letters and giving them backup information, attempt to basically persuade them. And in the end, they weren't persuaded. But
well, I think you should just distinguish yourself from those particular sites that you referenced.
Okay, I think that's a good suggestion.
Okay, so I guess either you can do that, or you can also have Mr. Freeman speak to why, in his report, he says that the other hotels are irrelevant. That's your choice, it's your show.
Mr. Freeman, would you care to respond?
Okay.
Good morning, Commissioners, Chair. My name is Jack Freeman. I'm here on behalf of the applicant. The Community Board, in their discussions at their hearing, said that at the time, new hotels had been built on West 24th Street and 25th Street. These were new hotels. They were built on West 24th Street and 25th Street between 6th and 7th Avenues, which is geographically a different locational district. They also filed for permits in 2000 and 2001. Working backwards, those hotels were probably in design stages in 1998 and probably acquired and assembled based on whatever the developers perceived for that area in the mid-90s. They put together their properties. So properties that were acquired in 98 are 5 years before this property. After this property we're looking at after 9/11, and we felt that because of the location, because of the time at which the hotels were under development, that they were really not relevant in consideration of the properties here. Also, in addition, the properties here only have the market of adjacent properties which can qualify for zoning lot merger. So a property on West 24th Street or West 25th Street cannot make itself available to acquire these development rights. So it's one thing to say, well, there's a general hotel market, but when considering whether or not there's a market for the development rights, one can only look at the adjacent properties and whether they represented an available market, not the general market.
Okay, but
So that was why I said they weren't relevant to this property, not that they were irrelevant.
Oh, I see. But to the earlier point, you said it's a different area. How is 25th Street a different area from 28th Street? Between the same avenue blocks? Like, what
I can
distinguish-
elaborate on that, but they're not on the same blocks. There's a
Right,
difference
okay.
between 6th and 7th Avenue. These blocks are, might be associated with the Flatiron District, not with the Flower Market District. It's locational consideration.
Okay,
So
so
both of the
you're-
properties being developed were being developed in a different market milieu, if you would. And we can make a statement to that, and I think that Commissioner Otley Brown's comment about, well, what was the market like post 9/11? These were really pre-9/11 developments. So geographically, in terms of the ability to utilize these development rights, and then I would just further note, and we can elaborate on that, that there was a hotel development on a potential receiving site going on at the time. We could assume 2003, even though the permits were not acquired until 2006. Had there been a demand for additional development rights, one would assume that they would have sought those development rights, and we don't see evidence of that. So even a parcel that could avail itself of the development rights did not see the market demand for those development rights. That would be my conclusion.
Okay, if you could beef up your statement and include all of what you just said, that would be, and back that
Glad
up,
to do
that
it.
would be great. Thank you. Any other comments from here? Are there any speakers? Mr. Bergman?
Good morning. See, we're going to have to invest in a gold-plated sign for you. So my name is Wally Rubin. I'm the district manager of Community Board 5, and I'm here to read a statement from the chair of our Land Use Committee. In 2003, the applicant sought and received a variance to allow for both the conversion from manufacturing to residential use of the second and third floors and the new development of 2 residential floors and a penthouse based in part on the representation that permitted uses prevented any reasonable possibility of a reasonable return, thus creating a financial hardship. A variance granting residential use is a benefit, making property more valuable than similarly sized and similarly zoned properties in a neighborhood. Residential use places additional burdens on a community, such as schools and parking. In 2005, the applicant sought and received in 2006 an amendment to the variance to allow for additional residential use in the form of a mezzanine in the residential penthouse. Now in 2014, the applicant seeks BSA approval through a reopening and amendment of their variance for the transfer of the unused development rights pertinent to the premises to an adjacent parcel in Block 804 comprising lots 30, 31, and 32. While the applicant refused to disclose the amount of the current sale, the 2008 transfer of 19,170 square feet of development rights from 145 West 27th Street to 146 West 28th Street, located a block south of the premises, for $2,369 or 123 per square foot, indicates the sale value of the development rights is certainly more than $2.5 million. When a property that received a variance due to financial hardship subsequently seeks to profit from the sale of air rights previously alleged to be worthless, the New York Court of Appeals in Bella Vista said requires that the BSA have jurisdiction over the lot merger and place their earlier finding in considerable doubt. The applicant claims that in April 9th, 2014 letter to the BSA that in 2003, there were no, this is a quote, there were no viable properties for the transfer of unused development rights to adjacent properties. Therefore, the findings made for these properties are not invalidated or called into question by the proposed merger. Landauer Valuation Advisory says in 2003 that signs of recovery were evident in the residential sector, but not in the hotel sector. There were almost no demand for hotel land or development rights during that period. But our own independent analysis shows that there was, in 2003, market for hotel development. Between 2001 and 2003, 3 new hotels, not 2, 3 new hotels were built within a quarter-mile radius of the premises at 116 West 31st Street, 158 West 25th Street, and 108 West 24th Street. The question before the BSA is not whether the unused development rights can be sold at a given point in time, but rather whether the totality of the property, including unused development rights, have a reasonable possibility of a reasonable return. While the identical ownership feature of Bella Vista is evidence of intentional manipulation of the variance process, separate ownership should not be seen as evidence of why air rights are not able to provide a reasonable return. And Community Board 5 believes that basic analysis of city records in the vicinity of the premises shows that by 2003, there was a clear market for development of hotels, including through transfer of development rights. And therefore, Community Board 5 recommended denial of the amendment to the variance for 111-113 West 28th on grounds that allowing a zoning lot merger to facilitate the sale of 20,000 plus square feet in development rights would place the premises in an unfairly advantageous position relative to neighborhood properties who previously had not had the generous residential use benefits afforded by the BSA in 2003 and 2005, and further allowing the applicant to sell their development rights after having received a hardship variance in a time of active hotel development would undermine the basis for the use of variance grant and offend proper land use regulation and application.
Thank you. Are there any other speakers? Okay.
May I just make a very quick response? The purpose of a variance is not to give a property more value than its neighbors. And that's not what happened in 2003, and it's not what happened in 1997. It's to make bring a property even with its neighbors from a financial status because it's overcoming hardship costs. So you don't get extra value before you have a variance. You get even with the other properties that are similarly situated. And I think that's a basic flaw in the community board's analysis, which is otherwise, very well thought out. And then finally, I just go back to Bella Vista and make an observation, if I can. That case was about what was close to a fraud on the board and required the board to take a hard look. Now, we're turning over rocks and we're taking out microscopes and we're looking at market conditions throughout the city. I don't think that's what was intended by Bella Vista, although it's understandable. The court didn't provide any guidance, it didn't provide any guidelines, it didn't provide any findings. So, people get a hold of stuff and it becomes more and more and more complicated. But the purpose of Bella Vista was to make sure that the board had all of the information that was relevant at the time it granted the variance, and that the applicant was not withholding information, relevant information from the board. And that's what that case is about. It's not about second-guessing the board's decision from years ago.
So we need some modifications on your materials, please.
Yes.
So how much time do you need for that?
3 weeks, please.
Okay. So again, how about a submission on the 4th of November? Sorry, the 5th.
The 5th.
And hearing on the 18th.
Thank you, that'll work.
Item number 5, calendar numbers 162 and 16395BZ, 3060 and 3074 Westchester Avenue, The Bronx, Warsaw, Bernstein.
Good morning, Josh Rhinesmith for the applicant. This is an application, it's actually 2 applications to extend the term of 2 special permits that permit the operation of a physical culture establishment on 2 separate zoning lots on Westchester Avenue in the Bronx. From yesterday's executive review session, I understand that some clarification needs to be made regarding the closing of the parking lot in 2012 and the gate that was proposed at that time. During the 2012 application process, through meetings with the community board, it came to light that members of the fitness center who were using the parking lot were hanging around either before or after working out, sometimes listening to music. And that loitering by members in the parking lot was causing disruption to neighboring property owners during the overnight hours. As a result, it was proposed to close the parking lot during the hours of 12 a.m. to 6 a.m. And a gate, a swinging gate was proposed. It was more of a bar-type gate rather than a chain link fence gate that would keep anybody out of the parking lot, but essentially to close the parking lot, prevent anybody from using it, thereby eliminating the noise issue. The applicant installed that gate. Unfortunately, just due to the size and the long boom, it became difficult to control and actually sometimes had hit cars and damaged them. So the applicant removed the gate and has put a chain link fence that keeps the parking lot closed during the overnight hours. We have received no complaints regarding noise since that has been done. And then I believe another question was relating to the usage of the fitness center. I don't have exact numbers on the number of patrons that come during the overnight hours. However, during the 2012 application process, we had done a survey of the number of cars that use the parking lot during the overnight hours to determine if it would create a burden to on-street parking. And the cars ranged from 1 during the middle of the night to 7 either at, I believe it was a time at 12:30, and then it was 6 at 5:30. And during those hours, Westchester Avenue, which is mainly a retail street, has sufficient on-street parking to accommodate that usage.
Okay, so if you could amend your facts and findings to reflect that?
Absolutely.
I don't believe we've had a community board sign recommendation yet on this, have we? No. So, when did you appear before the community board?
We have not. We had originally been in touch with the community board when the application was filed. And then during the summer months, the community board not met. I had some email correspondence with the district manager and basically saying that we had satisfied the community board's conditions. I would say it was inferred at that time that that was going to be the community board's recommendation, but I will reach back out to the community board and see if they, what their position is.
Okay. Okay, because there's no gate, and if the object was to prevent loitering, you can obviously step right over the chain. So
sure.
If loitering was the issue, we just need something from the community indicating that loitering is no longer an issue.
Okay.
During those
Understood.
closed hours. Okay.
I also believe there was a question regarding an open ECB violation. The ECB violation was issued in 2011, right before this the last extension, for occupancy contrary to the C of O, which the C of O had been expired at that time. The applicant obtained new C of Os, but didn't, so they cured the actual violating condition, but they didn't remove the violation of record. So once another extension is granted, we can update the C of O and then file the necessary certificate of correction.
Are there any other comments on this? Thank you. Are there any speakers on this? No, okay. I think we can, so if you could submit those materials, so we can close this hearing and leave the record open for you to submit the materials, and then you could, sorry, I just lost, let's see, what's today, the 20th? Yeah, I think, again, a submission on the 4th and the hearing on the 18th. 5th. Sorry? 5th, sorry, on the 5th, and a hearing on the 18th.
Okay, thank you very much.
Thank you.
And a motion to close?
Motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Ali Brown?
Aye.
Thank you.
Item number 6, calendar number 4208BZ, 182 Girard Street, Brooklyn. Eric Palatnik.
Hello, good morning again, Eric Palatnik. We attended your review session yesterday, and we understand the board's question about the home, whether or not it's compliant with the flood regulations. I spoke with the project architect last evening. It is, and we'd like to make a submission to you that the last set of plans, the last set of approved plans you have are not the plans that have most recently been acted upon at the Department of Buildings, which reflect the flood regulations which have come into place since this application was originally approved. The home is being raised a few feet, I think 3 feet, which is all that's required for it to be raised. It was not red tagged, nor is the enlargement increasing the value by more than 50%. So by Department of Buildings regulations, the raising of it by 3 feet will be compliant. But we'll submit to you a letter that documents that and provides you with a little more information, as well as with what the architect has accomplished at Department of Buildings.
Okay, great. Okay, great. So are there any other comments on this one? Are there any speakers on this item? Okay, so I think we can also close this and leave the record open for
Thank you.
to submit that. So again, submission on the 5th and hearing on the 18th of November.
Thank you.
And a motion to close?
And motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Ali Brown?
Aye.
Thank you.
Item number 7, calendar number 15908BZ, 68 through 70 Spring Street, Manhattan, Greenberg Trard.
Morning, Chair Perlmutter, Commissioners. My name is Jay Siegel. I'm an attorney with Greenberg Traurig, and I represent the owner of the property. At your review session yesterday, you had questions about why the construction had not been substantially complete as of February 2013 when the variance expired. With me today is John Zaccaro Jr., a principal of the owner of the property, to explain to you why it was not feasible to do so. John?
Good morning. As Jay Siegel mentioned, I am John Zaccaro, and I am a principal in P. Zaccaro Company. It's a third-generation development, management, and investment company. As you all probably do remember, we got our approval in 2009, which was an interesting time in the real estate business. We had, obviously, Lehman Brothers going out in 2008. Then we had the subprime mortgage. Then we had Teswell, which created an environment for ground-up construction that was difficult to fund. And then there was all the other complications that came after that. We actively, at that time, were pursuing 2 ground-up development projects, one on Sullivan Street and one on Spring Street. We went out into the market to get that, and it was very difficult, one, to get construction financing at the time for the size of this project, which was about a $30 million project with, if you include the land value. And what had happened was not only did we have reduced valuation for the property, the increased amount of capital that it was required to go in on the project, there was It required more capital, personal guarantees, and all the like. We decided to move forward with the Sullivan project, which was less complicated. The Spring project is in front of the subway. It requires TA approval, requires the underpinning of potentially 5 to 6 buildings. In addition, that project requires a coordination of a very complicated street. We went with Sullivan first, and in fact went out into the markets, where we finally got a loan commitment in 2011, did not close the loan until 2012, and was unable to break ground due to the delays from Con Edison and other service providers of closing down the service to the building for us to do demolition until after our variance would have expired on this one. In the interim, we have gotten Spring Street all set and put in the pipeline. We have our construction documents ready to be submitted to the TA for approval, and we're ready to move forward to take down a construction loan as soon as the approval from the TA is done. So I don't know if you have any other specific questions.
So you were in continuous ownership from the time of the grant until today?
Yep, yep. I think since we've been in ownership of that property since 1970 and have been in Soho since 1970, which it has slightly changed.
Any questions for Mr. Zaccaro? No? Okay, thank you very much.
Thank you for your time.
Thanks. So, Mr. Siegel, if you could take some of what Mr. Zaccaro said and incorporate that into your facts and findings, that would make it a more complete story. Okay.
And yes.
Any questions for Mr. Siegel? Okay. Are there any speakers on this item? Okay. Okay, I think we can close this also and leave the record open for you to resubmit your...
Just to given the season, 2 weeks, it's okay.
2 weeks, yeah. No, it's actually longer than 2 weeks because of the, oh, actually, we could probably do, let's see, 21st. Yeah, given the time, we could probably make a submission on the 21st.
Sure.
And hearing on the 28th.
Thank you. Perfect. Thank you.
October 21st, October 28th.
It's okay, because it's good. Just a what? Yeah. Of October, yeah, of October we're talking about.
Yes.
Yes, okay.
Motion to close?
Thank you.
Motion to close.
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Ali Brown?
Aye.
Confused about this.
Appeals calendar, decision items.
Those ones I could have moved.
Item number 8, calendar number 14514A, 136-16 Carlton Place, Queens. Yaklem.
For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Ali Brown?
Aye.
Thank you very much.
Continued hearings, item number 9, calendar number 300-08A, 39-35 27th Street, Queens, the law office of Marvin B. Mitzner.
Morning, Madam Chair, Commissioners. Marvin Mitzner, the applicant. I believe the board is in receipt of a communication from the Department of Buildings dated September 17th, where the department has reviewed the zoning on the site and has determined that there is no new noncompliances or any increase in degree of noncompliance as a result of our inclusion of an as-of-right parcel in connection with our vested rights parcel. All right, this does not affect, the addition of that parcel has no impact upon the prior grant of the vested rights, because the vested rights parcel is still consistent with what was approved by this board under vesting and what we're entitled to build under vesting. The addition of an as-of-right parcel doesn't change that. The addition to 25 by 100-foot additional parcel fully complies with the new zoning. And the portion of the site that is under vesting complies with the prior zoning. And the Department of Building has confirmed that.
So part of the confusion about this application is, as you describe what it is you want going forward, you don't describe at all what it was what was approved in the original variance. So so it's impossible to actually compare the drawings that you provided of the building that is the subject of the variance today with the building that was the subject of the variance when it was granted in, whenever that was, in 2010.
Right.
Right? So what we're doing is kind of by recollection, remembering that there were 2 elevators inside of the originally approved building. And now there's only 1 elevator inside of the originally approved building, and the other elevator is in the new building on the site that's that's subject to the M12 zoning. So elevators don't count as floor area, right? So elevator bulkheads don't count as floor area.
Bulkheads do not count, the elevators
Yeah,
count.
elevators do count. So, but the concern is about your relocating floor area off-site, like mechanical space for the elevator, for example, wouldn't count. And so what we can't tell is how your mechanical deductions didn't get modified in the relocation of the elevator to the other building. And that's the question. And the other part of it is that the drawings that were provided don't make any reference at all to the Long Island City Special Mixed Use District, so it's not clear that the Buildings Department understood that this was in the Dutch Kills area. There's absolutely 0 reference to those sections in the zoning resolution, so it's not clear that the Department of Buildings was reviewing a complete analysis.
All right, well, I can tell you that it does comply with the Long Island district, special district. This lot is located in the Dutch Kills sub-district, and the Dutch Kills sub-district is very specific in how it changes the underlying zoning, and it doesn't affect what we're doing on the site because most of those changes involve residential development, and this is a hotel development site. So, but we can clarify that.
But it needs to be clarified,
right,
because it's guesswork on our part. So in your statement of facts, you really do need, and in the submissions, you really do need to tie what was approved in 2010 to what you're proposing to do now, so that it's easy to make the comparison and to understand what the differences are between the 2 buildings, because at the moment, it's just the history is missing. And you're asking us to sort of guess what the history is and figure it out for ourselves.
Well, we'll try to take away that guesswork and make it clear as to what changes there are. There aren't that many significant changes, and we haven't really changed what was part of our common law vesting. But we'll clarify that in
And then the next part of it has to do with, in your original 2010 vesting application in 8, you showed an expenditure of $820,000. It's not clear what's going on with the construction on this site. Like, why is it taking so long?
I think we've explained it. But we can explain it in greater detail if you wish. But part of the concern is that we've had some difficulty at the Department of Buildings issuing certain stop work orders based upon an interpretation which they later recanted. And it took the owner quite some time to convince the Department of Buildings that those violations and stop work orders were issued in error.
That's with respect to the E designation is what you're talking about?
Yes.
Was that the only stop work order that was issued against the building?
There are other violations issued, but they've all been cured. We haven't yet had an inspection. I think I mentioned that at the last hearing. But the owner has scheduled an inspection by DOB to officially remove those violations.
Do you know when that's going to be held?
No, I don't. He scheduled one. It should be held within the next couple of weeks.
Well, we'll get into the stop work, so I'm sort of just going down a list at the moment. The other thing is you provided, the application was submitted in April, and you provided photos and costs relative to April. Can you update that to reflect where we are today in September?
Yes.
So this sort of just brings up where we are and what's kind of really going on at this site, because, we can just talk about this as an abstract concept of you've been working on the site, you're not finished yet, and then you want an extension to finish, but there's a lot more, as you know, that's going on with the site. So, for example, at the time of your vesting application in 2010, the board actually noted a number of violations on the site and actually improper behavior with respect to project management that resulted in the issuance of stop work orders and resulted in work being done in violation of the stop work orders and the requirement that the board imposed that you not include costs associated with work done during the stop work order period. So it seems as if the behavior, the project management, the site supervision, the quality of the architecture and engineering has not improved since 2010. And that at the moment there are open ECB lot violations, quite a lot of them, and DOB violations, and many complaints. And we received a lot of complaints from neighbors about current conditions that are actually hazards on the site, undermining structures adjacent, and other kind of behavior that's just really not acceptable on any project, and especially on a project that's coming to the board to ask for some kind of special relief. So my first question is the owner of this project here?
No, he's not.
So for the next hearing, I would like you to bring the owner here. The owner needs to address, frankly, bad behavior on the site, and how this is going to be addressed prior to us being willing to grant on the vesting application.
Sure.
Yes.
Yeah, to me, one of the disturbing things about the open violations, I think there's about 14 of them, is that they were received after our grant of vesting. So these are like continuing problems, things that happened after in 2013, 2011. So I'm concerned about that.
All right. Well, I understand. We will take a look at those violations, address them, and I'll have the owner explain where he's at with those and what transpired.
There's still an active stop work order on the property, and it doesn't appear that your client has moved to try to lift that in any way. And I'm wondering if that's because there's still additional work that needs to be done, that the building department has not been satisfied, leading to not getting the inspection yet because there's still work that needs to be done. I think I'd like to see sort of a full report on the violations, how they got cured, make sure that they got inspected, because DOB, it seems that their site doesn't indicate that really any movement has happened since you've been here. So that's significant.
All right, we'll follow up on that. I've been told that most of the violations, particularly those that relate to some of the sidewalk shed issues and protection issues, have all been taken care of. But I'll get clarification on that.
It's not on the site.
Understood. And as I explained, he hasn't had his inspection yet, but he scheduled it, so I'll have him clarify as to when that inspection will occur and what the results will be.
The main violations are not sidewalk shed related. They're related to structural issues, underpinning and undermining adjoining structures and inadequate structural systems. They're very significant violations. And so for your client to prepare for coming here for the next hearing, they need to come also with a plan for how they're going to rectify site safety, how they're going to improve the project management of this project, because obviously they're not very good at this. They've been doing a bad job for a long time, and that should not be encouraged by this board's grant. Mm-hmm. So there needs to be a correction in behavior first.
Well, as I said, we'll have the owner explain what he's done to correct any problems that existed on the site.
And what he's going to do in the future to ensure that there are no further problems.
Certainly.
Okay. Any other comments?
Yeah. When your architect looks at the plans, I had a question about the 6th floor terrace and the 8th floor terrace. an M12 portion. When I look, you didn't give us really any elevations or sections, but it looks like it protrudes into the sky exposure point. You're required to have a setback on the 4th floor, and these terraces come all the way out to the street wall, according to your plans, and I don't see how that's possible.
That's in the new portion.
Yeah, I'll take a look at that, but as I say, the building department has reviewed it and has found to be compliant. But
Right.
we'll take a closer look at that.
Can you give more detail as to your serious loss in terms of from what was invested? Can any of it be reused? If not, you need to talk about why it can't be reused. And then you should talk about if you aren't granted the extension to complete and you would have to comply with the new zoning, what would that do to your income stream?
Mhm.
So if you can address that, that will complete that section.
Okay, fine.
Okay, thank you. Are there any speakers on this item? Okay, so how much time do you need to respond to these questions? Sorry. Oh, you think there are speakers? Okay, there may be speakers outside. Hold on one second.
We have a lot of others.
There's just not a lot of chairs.
No. In any event, we'll need about 3 weeks to middle of October, I guess.
Middle of October.
Let's see.
Suppose, could you submit on the 14th, or is that too soon?
A week later.
A week later, on the 21st, and hearing on the 28th? Is that too soon? Probably. Push into November with this site? Yeah, okay, I'm sorry. Yeah, so I'm sorry. If you could submit on the 5th of November and come to hearing on the 18th of November. Yeah, it's just the calendar is very full in October.
Okay.
Okay, thank you.
There
are no speakers? Okay.
I asked out there.
Okay.
So it's submission on November 5th,
and hearing on the 18th.
Okay, thank you very much.
Thank you.
Item number 10, calendar number 2314A, 198-35 51st Avenue, Queens. Eric Palatnik.
Hello, good morning again, Eric Palatnik.
Are there any questions for Mr. Palatnik? Okay. I think we can close this, and I don't think there were any submissions. So,
I think there is a speaker that wants to speak.
I'm sorry. Are there any speakers on this matter?
Good morning. My name is Henry Euler. I'm the first Vice President of the Auburndale Improvement Association. I'm also a member of Community Board 11 in Queens, but today I'm representing my civic organization with this testimony. The case was heard by Community Board 11 at the April 2014 monthly meeting. The board voted to disapprove this application, with 33 voting to disapprove, 9 voting to approve, and 1 abstention. On October 27, 2010, the Auburndale rezoning was enacted and changed the zoning for this particular property, in this case, from R32 to R2A, which is a one-family district. The new house constructed on the site is a two-family home. A question arose at the community board just when the foundation was poured for the new house on the property. Apparently, the Department of Buildings saw the property on November 1st and said that the foundation was in. The applicant was asked to supply the board with a sworn statement from the contractor who actually poured the foundation to establish with certainty if the applicant was entitled to build under R32 regulations or not. From what I know, no such statement was ever produced. The disapproval by the community board was based on the owner's failure to follow the procedures to gain vested rights. From my understanding, to have vested rights, the owner was required to obtain a certificate of occupancy within 2 years from the zoning change. The owner did not do this, and provided no cogent reason why there was a delay in completing construction and obtaining a certificate of occupancy. There was also a question about the side yards of this building, which seems now to be resolved. Because it's not clear when the foundation was actually laid, and because the owner did not follow the procedures to gain vested rights, my civic organization concurs with the majority of the community board and urges the Board of Standards and Appeals to disapprove this application. Thank you for allowing me to testify today.
Thank you. I just wanted to explain, though, that there's two methods of obtaining vested rights, one of which is known as a common law vested right, where the owner has to demonstrate that it made a significant investment in the property, and that can go towards establishing it, so you don't need to get anywhere near certificate of occupancy level.
I see.
It's just a significant percentage of the total development cost will qualify for vesting.
Thank you.
Any other speakers on this item? Okay. So, as I said, we can close this for a motion to close.
Chair Perlmutter?
Yeah, aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
And whatever we're up to, could be on the 27th? I mean, sorry, on the 21st? On the 21st?
October 21st.
Is it okay? Is that all right? Decision on the 21st.
Thank you.
New cases, item number 11, calendar numbers 5709A through 11209A, and 12909A through 15209A, Santa Monica Lane, El Camino Loop, Moreno Court in Staten Island. Eric Palatnik.
Hello, good morning again, Eric Palatnik. I know you reviewed the application.
Are there any comments on this? Are there any speakers on this item? Okay, so we can close this also.
A motion to close?
Decision. So for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
And the 21st also is the decision.
Thank you.
in October.
Thank you very much.
Item number 12, calendar number 9514A, 237 East 72nd Street, Manhattan. Bernard Marson.
Good morning. My name is Bernard Marson. I'm an architect, and I'm here on behalf of my client who's with me, Mr. Anthony Marsabilio, who has engaged me to help expand his apartment to accommodate his family of himself, his wife, and two preteen daughters. He did not engage me until he had already gone to the Department of Buildings and asked if such an expansion was possible, and he was told it was possible. After he engaged me, we went together to the Department of Buildings, and the Department of Buildings, the examiner told us that we could expand, but not beyond the 25% of the largest floor area, which is one of the provisions of the multiple dwelling code. I made another trip to the building department to talk to the chief examiner because I had a question as to, when I made this expansion, whether the existing scuttle, they did not have a stairway to the roof, they had a scuttle, whether I could keep that and still put the penthouse in. And I was assured that I could not do that and I should put a stair bulkhead in. So I did so, and then I made drawings, and then we have this objection also from the multiple dwelling law that you cannot increase the height of a converted dwelling. And that's what we're asking you to provide a variance for. Now, I listened to the video of the comments, and I'd like to answer the comments one by one, and you may feel free to interrupt me if I don't answer it adequately.
Okay, a lot of it will be a resubmission of drawings, so the comments would be responded to in the drawings, actually. Our main comments were we couldn't understand what it is you're proposing to do because your drawings are only from the third floor up, And since this is fire safety related, we need the first floor or even the cellar.
I would like to address those comments.
You're not
First,
gonna
first of
provide
all,
the drawings.
what's that?
Is your comment that you don't think you need the drawings? Because that wouldn't be the right answer.
Well, it is. If you don't mind, let me say this. I've done work on individual apartments within multiple dwellings many times. It's never been necessary for me to show the apartments in the multiple dwellings. This is a legal, perfectly legal, 4-story brownstone, that is 4 stories. It's a basement, first, second, and third floor, and I'm only doing work on the penthouse. So I showed the floor just beneath the penthouse and how I'm improving the stairway, the stair bulkhead, which I thought was proper. I'm not against showing these other drawings, but it's never been necessary for me to do it before in a multiple dwelling.
Right, so you're correct. When you submit for a Department of Buildings approval, you only show the area of work being affected, but when you're asking for a waiver of the multiple dwelling law where it has to do with fire safety, it's a whole different series of...
I plan to address that fire safety issue also.
Okay, but so the answer is, in order for us to understand fire safety, we have to understand the egress in the building of...
May I explain this? This is a 4-story brownstone. Basement, first, second, and third floor. There's one apartment per floor.
Okay.
The apartment opens onto the stairway.
So, you know what, I think the confusion on your part is that the multiple dwelling law is a mysterious place. I grant you that. It's a very strange set of regulations. You should probably look at it with respect to the conversion of buildings. What is it, section 171 of the multiple dwelling law?
171.
Yeah, take a look at section 171 of the multiple dwelling law where buildings are permitted to be enlarged, not a converted building, but other buildings are permitted to be enlarged, and look at what's required to be done to those buildings in the event of a 1-story enlargement to, say, a tenement building. And you'll see what we're getting at. In that case, just to add 1 floor to the roof of a tenement building, there's a huge amount of restructuring that's required by the multiple dwelling law in order to make the building safe enough to allow for that kind of that egress and the additional fire spread that is potentially caused by adding that additional floor when you don't have a fireproof building. So that's the confusion. You need to look at section 171 and then you'll understand why we're needing to know everything about the building and why you will be asked to do much more to protect the building than just what happens on the 3rd and 4th floor.
I'm not against looking at 171 again. I've spent a lot of time on 171, okay. But I would still like to answer your comments the way I see it and see if you, if it clarifies. You say the 3rd floor and penthouse and I did not show other floors. And as I said, it's usually not required when you're doing work in a multiple dwelling. You say the details have nothing to do with fire ratings, but the details show the construction necessary to achieve the required fire ratings. That is, it shows a detail of 2 layers of type X gypsum wallboard on each side for a 2-hour rating. The details carefully show that. You made a comment the stair is exclusively for the new penthouse and it doesn't go to the roof, but it does. There's a new stair bulkhead, which is an improvement. This building previously only had a scuttle to the roof. And it goes directly to the roof with an opening to the new unit at the penthouse. This shows on my drawings.
Doesn't the penthouse, the 3rd floor, you're in the kitchen, living room area, you go out into the public corridor, you walk around, and you come into the bedroom?
Yes.
So that's supposed to be 1 unit on that floor and you go out into the public corridor?
I deliberately did not call it 1 unit because I did not want to include a stairway within this space. The space is very limited, and I call the new penthouse a separate unit.
But it only has a bathroom and a bedroom. How does it?
It comes to the definition of a separate unit, which comes in
Article
1, Section 4, Paragraph 4, a dwelling is any building or structure or portion thereof which is occupied in whole or part as the home, residence, or sleeping place of one or more human beings. It is a separate unit.
So you're trying to file it where it's not a penthouse, it's a fifth floor unit without a living space?
It has a...
Without cooking and without...
Without cooking. It has a living space and a bathroom.
So then,
in other words,
what is that then? Is that a transient use?
No, that's a permanent dwelling according to the definition in Article 1, Section 4, Paragraph 4.
Single residency occupancy?
Under multiple dwelling.
I'm sorry, I'm not familiar with how you can have apartments and then on the roof you have an independent unit of another family living up there. Why don't you want to include this as part of the...
Because I want to avoid the necessity to connect them with an interior staircase.
So then...
Mr. Marsabellio's 2 preteen daughters will live there. It'll be their multiple dwelling unit. They'll have beds and workplaces and bathroom.
And you want not to... And how about accessing from the kitchen and living room to the bedroom on the 3rd floor? You're going out into the public stair, coming around and in.
Well, when many people visit another person in a unit, they use the public staircase in a multiple dwelling. So their daughters, when they visit their
parents... No, not the daughters. I'm talking about on the same floor, on the 3rd floor. If I remember correctly, you have to exit the bedroom. Yeah, right here. You have to exit the bedroom, go into the public stair hall, and then into the kitchen. And actually, now that... Yeah, into the kitchen and living room. So the public stair hall is being incorporated, being treated as if it's all part of the single unit, as opposed to a fire stair where everybody in the residence can run up and down the fire stair to the roof. I mean, essentially you're mingling residents on the lower floors with your private dwelling.
No, I don't think this harms anybody.
And in actuality, it looks like you're providing not only the 5th unit, but maybe the 6th unit. Because if I have a separate entry into that bedroom on the 3rd floor, under your definition, one could say that that's a unit, and then I've got another additional unit at the penthouse level. So haven't you actually increased it by 2 units?
I hadn't thought of that, but if that's the case...
That's what you're showing.
If that's the case, I
me.
might even say, so what?
But you said yourself you have a limit on 5 units in the...
I didn't say I had a limit on it.
Yeah, you did. In your applications, you said when you do the math, there's a 5-unit limit, and you hit 5 units, and according to this, you've hit 6. According to what your reasoning is, you've hit 6. I'm just confused about why you want to make this so hard.
I didn't want to make it hard at all. I only wanted to build a little penthouse for my client, and I am confronted with these abstract rulings that don't hurt anybody. Let me start again by saying this is a legal building. As for all the fire safety requirements, they have all been met. When this building was converted, I have a note on this, it was completed on March 8, 1973. One of the provisions states, in lieu of the requirements of the subdivision, a sprinkler system may be installed in accordance with the provisions of the section to accommodate the wood doors. This was legal. In other words, this is a legal building now.
Before you add the floors, so what's happening...
Now, when I add the floor, if you don't mind my saying, I'm increasing the fire safety. I'm putting 2-hour rated walls on the 3rd floor apartment. I'm building a new bulkhead stairway, which has not been there before and which is not otherwise required, but which is making it safer. And I'm doing all kinds of things, including sprinklering the 3rd floor apartment and the new penthouse. So I'm making the building safer in every respect.
Well, actually, so the concept behind the converted dwelling prohibition is the view is that the buildings are not safe for more than a certain number of occupants in a certain size because of the construction class. And so that's why it's completely prohibited by the multiple dwelling law to add anything to this building, right? So unlike Section 171, where there are ways around it, where you can actually, okay, you want to add that floor, you're going to have to do a lot of work in the building, right? Under the multiple dwelling law, no addition is permitted in a building like this. So when you're coming to us, you're saying, let me have an addition, so we have to try to come up with ways to make the building fire safe when it's the state multiple dwelling law, determined that these buildings were actually not safe for enlargement. So to say, let me just enlarge it and put a couple little sprinklers in, that's not satisfactory to overcome the entire prohibition of an enlargement of a converted dwelling. So you would need to make some much more significant changes to the building in order to be able to justify what I understand is a very small enlargement, but nevertheless, that's what...
Just so we understand each other, as for the occupancy, Mr. Marsabilio's preteen daughters are now living in that one-bedroom apartment. He's divided the living room in a way. So the occupancy will not increase, actually, with this new unit.
Well, it has to do with a family count. So once you're deciding that there's multiple units, according to that, you can kind of rent this out as a rooming house, effectively, right? You've created all these different units. So you're saying it's a two-family unit or something, two-family dwelling, but you're treating it as if it's a 5 or a 6-family dwelling. So you have to decide which one you're doing, so we can apply.
The building is a legal multiple dwelling now.
Right, but at the moment, that's what's hurting you. If this was not a multiple dwelling, the reason that this is an issue is because it's a multiple dwelling. If this were a single-family unit or a two-family unit, you're not even subject to the multiple dwelling law.
Of course.
So if in fact you've got a family living on 2 through 3 and the penthouse, that's one family, then the ground floor is another, then the multiple dwelling law doesn't even apply to you. So it'd be a lot easier if you called the rose and took care of it like that.
But it is, unfortunately, a multiple dwelling, and Mr. Marsabilio does not own the building, and I have no authority to go into anybody else's apartment. I'm only dealing with his apartment and the expansion.
Well, I'm confused. So your family lives, his family lives on the second floor also?
No, it is the top floor, which is the 3rd floor. You might call it the 4th.
They live on the top floor, and someone else entirely lives on the 2nd floor?
Other people live on the
totally
basement, the 1st and 2nd floor.
Okay.
There are 4 units existing in the building now.
Okay. So, I don't really know how to explain this any other way. You're converting, you're adding floor area, or you're adding height enlargement to this multiple dwelling. The multiple dwelling law prohibits this when it's a
That's why I'm asking for the variance.
And it prohibits it for a reason that has to do with fire spread and fire risk, right? And so, in order to enable this enlargement, in order for us to have the power to do this, we have to impose safety measures that are strict and more extreme than what you're suggesting. So if you're not able to do that, I'm not really sure how we're going to be able to give you this waiver.
I don't have the authority to go into any of the other apartments. I don't know what you would propose for me to do in these other apartments anyway.
Okay.
I think maybe what might help you to understand perhaps what we're asking. We look at the building in totality, holistically. So the information that we're going to need is you need to tell me what that building is right now. Show it to me. Show me how many units you have in the building, in the entire building. Give me the basement plan, the 1st floor, the 2nd, the 3rd, existing. Tell me what about that building. You said that there are sprinklers in the building.
In the stairway.
So fine, but then show that to me. Tell me how that's going to now fit into what you're asking for. You're saying, well, I'm going to continue the sprinkler system. I'm assuming that's what you're doing. Tell us how and why that would fulfill sort of our requirements in fire safety. You've got to tie in what you want with the entire building. It's not just your unit that we look at. You've given us just your little snapshot of the 3rd and 4th floors. We don't know how what you're requesting, how you're saying you're going to satisfy multiple dwelling law, how that ties in with the rest of the building. You're letting us guess this. So without guessing, I'm saying there's nothing else there. Anything that you're doing is probably just new, and there's nothing in that building that you're tying into. You have to look at how people are going to exit, right? You have to look at the egress in the building to make sure that everybody below you is able to get up to the roof or get downstairs. So you have to show us that, and you have to then propose to us how you can fulfill those safety requirements vis-a-vis fire and et cetera for the entire building, not just your piece. Because we can't give you something and endanger people below you. So you're going to have to show us how the entire building works together. Am I making sense?
I hear what you're saying. I thought it would be clear that there's one apartment per floor and there are 4 apartments, but I will make
You didn't give us the drawings to show us that, did you? Right? So
But I say there are 4 apartments.
I'm an architect. I look at drawings. You can tell me anything you want.
I'm happy to make the drawings.
Unless I actually see it.
I'm happy to make the drawings that show those apartments. I might not show the interior partitions of those apartments, but I will show the stairway on the basement, first, second.
And show us how your proposal makes that whole building safe, not just your.
I'd be happy to do that.
Can I add something?
Okay.
I'd like to add something. Can you also address how the use of that stairwell on those top 2 floors, the 3rd and now the 4th, is as a private dwelling stairwell as well as a public egress stairwell doesn't compromise the safety of the people below, should they, number one, have to use that stairwell to get to the roof, and also as regards keeping that stairwell isolated from any possible fire spread when you've got an apartment that's going to utilize that staircase as an internal circulation. So you may have doors that have fire rating and are sealed, but if those doors always remain open because it's like somebody's apartment, then it's not going to do anything to contain any fire that may occur in that apartment.
I agree, but of course the doors are self-closing doors.
But that's.
They're fireproof self-closing doors.
It's called a hook.
I beg your pardon?
It's called a hook with an eye that holds the self-closing door open.
There are many things that are done illegally.
No,
I mean,
no,
we're not
it's
planning to do anything illegally.
You're living in your apartment. You want your room open, so the door open, so you get better cross ventilation. You're definitely gonna. You don't close every single room in your bedroom.
Well, isn't this true of every multiple dwelling in America? Can't you say, gee, they might put a hook on that?
Yeah, but most of them have personal internal, if they're duplexes, have personal internal staircases that aren't somehow compromising the safety of the rest of the building. So if you have an internal staircase to get from one floor to the other, you can keep those fire safety rated self-closing doors shut that go to the public stairwell because you're not using that unless you're leaving the apartment. But in this case, anytime the daughters want to come say something to their mother, they have to go out into the public staircase and take that downstairs. And in all probability, you're not going to keep those doors in the closed position.
In addition to which, because we know what it's like to have a staircase, we use it to store things. When it's our staircase, when it's part of our unit, we put bookcases in it, we put bicycles in it. That's what you do with stairwells. We've all been in buildings where the stairwells are nice storage areas, but this is a fire egress. It's different. It's a fire egress of a multiple dwelling, not of a single family townhouse where you fill up stuff in your staircase, but it's at least one family living there with their own methods for egress. Here, the chances that this stairwell becomes filled up with stuff and endangers fire department and other residents below is real. It's a real risk. And I just want to also point about the drawings. The reason that I'm also an architect, the reason I couldn't figure out what your fire rating was of your interior walls is because though you have sections, you have wall sections, you don't indicate where they're going to be used. So you have those nice little triangles that don't have a number in them, and then on the drawings, there's, on the plans, there's no indicator that little triangle is wall section number 3 or number 4 or number anything, so I don't know.
But they are labeled. They are labeled, and of course, I do show in the legend by coloring which walls
No,
are
I don't
2-hour
know-
rating.
I don't know which wall section applies to which place. So labeling isn't good enough. We know how you label a wall section, right? Or in a plan, how you indicate which is the fire-rated wall, which isn't, which is the fire-rated detail. We need to understand that. And there's no excuse for why the details are not coordinated with the plans. So you do need to combine those together. Buildings department would make you do that as well once they get the drawings.
I will do so. As for how I promise that the stair will remain open, I mean, can I get an affidavit from Mr. Marsabilio? What would you suggest? How would I
Really,
keep those doors closed?
It's hard to understand why you can't put a small staircase to get up to.
There's a very small area involved, and there's hardly room for bunk beds and a desk.
For instance, you can be using the fire stair to move beds. So you could have in terms of other kinds of accessibility, that staircase could, in terms of handicapped accessibility, you have a stair with normal risers and so on. So on this interior stair, you probably, I'm not sure, you probably could get away with a very small stair, not a substandard, not a full-size staircase. That's a buildings department call, but it seems to me that because you have that access in 2 different ways, they might allow you to use that, have that interior stair be smaller. So
I will look into.
right,
I will
it's
do.
very hard to understand how this is going to actually work without endangering the residents below, and actually how the owner of the building is going to allow you to do this, frankly.
I will make these changes.
Okay, thank you.
Also, I had one other question. In your application, when you talk about requesting a waiver to MDL 310, you have to show practical difficulty, and you should talk about why a horizontal expansion is impractical, and you should explain that in your facts and findings and not just dismiss it with the sentence that says horizontal expansion is impractical, period. You have to, you have to convince us. You have to complete the application, make it a full application to meet the findings.
And it's evident, you don't have control over the lower floors.
Well,
there was no way for us to know that.
Right.
We didn't know this was owned by
right.
someone else.
It can't be expanded because it's a 3rd floor space, and it can't go over the street, it can't go over the party walls, and it can't go into the...
Right, that should be in your
I
narrative.
will write it in.
Okay. And then the other thing is, in terms of the area of the addition on the roof, you're saying it's staying within the 15% limit, but you don't provide the area of the roof or the area?
I will put the arithmetic in.
Okay, thank you. Are there any speakers on this item?
And just make sure that you also take care of whether or not you're asking for 6 units or the 5 units.
I will.
Okay.
I will clarify that.
And
I suggest you stick with the 5.
Yeah, I suggest that too. And I'd also suggest, just to clarify, where to provide the authority for having this unit that only has a bathroom in it as a unit within a multiple dwelling that is made up of units that are, full permanent residence units as opposed to one that's just got a bathroom. When I'm thinking of this, I'm thinking of SROs where they have no kitchen, but they have access to a kitchen. So I'm a little, I'm feeling like you're mixing typologies, and I'm not sure that that's permitted. So I need more legal support for that unit that is independent like that. But it won't matter if you're just going to put a staircase on the inside, which would be the best solution.
All right, thank you very much.
Okay. Fire department, thank you.
Good morning, Madam Chair, Commissioners. Anthony Scaduto, representing the Fire Commission. And first, let me congratulate you on your appointment.
Thank you so much.
This particular project is extremely problematic. I think we can see from today's meeting that we have a ways to go before we can move along. Certainly, the Fire Department is not in any position to recommend any kind of approval, or we cannot support this in any way. I'll start by clarifying some of the issues that I think you were alluding to be more specific. First of all, this is a vertical enlargement in a non-fireproof building. The first thing that I see, which the plans are not sufficient, there's a void that's created when you're placing any kind of a structure on top of an existing non-fireproof building. There's a void that's created. What I see on the details, the 8300, I see that beams are being placed on the existing combustible roof, and there is no fire stopping of any sort, nor is there any sprinklers installed in that void that's created. So that any additional or any new drawings that are provided, I'd like to ensure that that's in there, at least some sort of note that's there, so that it's not a problem when it gets back to the Department of Buildings. It's you know, any vertical enlargement on a non-fireproof building, that's an important concern. Relative to the new bulkhead, in addition to the issues that you're discussing, this particular addition, the penthouse, is placed in the center of the roof of this particular building. Being that the roof is a means of egress in this type of a building, what the fire department would require is that the bulkhead have two doors, one leading to the front roof and one leading to the back roof. Again, this is a non-fireproof building. The roof is a means of egress, and if the front of the building is involved in a fire, I need to know that the occupants of the building are able to escape out onto the rear. That may require some sort of design change in the floor plan, but frankly, the fire department cannot support this application unless the entire exposed third floor roof is accessible. The scuttle ladders that are provided over the new construction are not adequate for escape, not adequate for fire department operations on the rooftop. We would need, from the interior, again, just to repeat, we would need bulkheads open on both sides, front and rear of the building. We've discussed the sprinklers. It is assumed that the existing stairwell sprinklers will be expanded to include, cover all added floor area, not just one placed at the top of the bulkhead, but certainly as the standard requirements in terms of spacing in any kind of interior stairs. The enhancement in terms of fire rating, again, from the fire department standpoint, we work the whole building. We don't just work a new addition. Any emergency that takes place in that building affects the entire building. If there is to be an enhancement, and there should be an enhancement of the fire rating of the walls, the enhancement should take place from ceiling to floor on every floor of that building. Any additional fire rating should take place on every public stair, as well as the public hallways, first through third floor, plus the bulkhead. We also need more information in terms of the existing materials that the stairwells are made from. I don't know if those stairs themselves are combustible or if they're non-combustible material. The addition of fire doors should be required on every unit in that building, top to bottom. Again, the fire rating enhancement only on the new construction doesn't provide any kind of safety for the building. The addition is creating a hardship for the residents in terms of egress, and it's creating a hardship for the fire department in case we have to work that building. We need to know that every enhancement that's made takes place on every location in that building. Let's see, the stair material, the treatment of the void. There are existing mechanicals on the roof of that building. I see no notation that they will be moved, where they will be, and how they will interfere in terms of fire operations in that building. So we will need information, regardless of whose responsibility it is, in terms of where they intend to place the mechanicals. And I seem to get these, just based on the floor plans, I see a door from the new unit. It appears to me that it may be a porch, balcony, or rooftop yard. We'd like to know if they intend to use that in terms of recreational space, and if so, if there'll be any permanent furniture or any installations which would create any hardship for the fire department and movement on the roof. And
You're talking about at the front of the building or the
front of the building, it looks like on the existing drawings, there's a egress door, and it may lead to what they intend to be a rooftop garden or a patio. And we need to know if they intend to provide any permanently installed fixtures, furniture, and so on and so on and so on. And I think that pretty much covers our concerns at this point. We have a long way to go before, like I said, before the fire department will support this project. But I think what I've listed should help the applicant understand the type of work we need to see before the fire department will support this. And I thank you. And if there are any questions, I'd be happy to answer them.
Thank you. Could you also, do you have that in writing by any
I will submit in writing. Unfortunately, I just started reviewing this weekend, and this was just my reaction after the first 5 minutes. I haven't even
gotten into it yet.
I haven't even gotten into it yet. I will, to the best of my ability, put down in writing everything that I stated today.
Okay, thank you.
Thank you.
Okay, thank you so much. Are there any other speakers on this item? Mr. Marson, can you come back, please? So I'm hoping that you took note of the fire department's comments, because that's what guides us in addition to our own experiences, right? And we'll give you a copy of their write-up so that you can follow along with that as well. But I can see now that because you don't own or your client doesn't own the building, I'm not really sure what the property owner's response is going to be to all of this and the additional expense that will be involved in all of this, and whether what you have is really a viable project for 289 square feet or some number like that, right? So, you know, that might be something to talk about with your client, whether this is really
Well, I'm sure we're going to talk about it.
Okay, thank you very much. You're going to need some time to correct the drawings and amend the application.
Yes.
So I'm thinking this is going to take a while. So let's see, the 23rd. You think a month is long enough for you to do this?
Yes.
Okay, so submit on the 5th of November, and the next hearing then would be on the 18th of November.
Thank you very much.
Thank you.
Decision items, zoning calendar decision items. Item number 13, calendar number 26513BZ, 118-24 through 47, Farmers Boulevard, Queens. Eric Palatnik.
Hello, good morning again, Eric Palatnik.
Motion to grant.
Chair Perlmutter,
Abstain.
Vice Chair Hinkson,
Aye.
Commissioner Montanez,
Aye.
Commissioner Ali Brown.
Aye.
Thank you.
Item number 14, calendar number 2114BZ, 11502 Jamaica Avenue, Queens. Eric Palatnik.
Hello, good morning again, Eric Palatnik.
Motion to grant.
Chair Perlmutter,
Aye.
Vice Chair Hinkson,
Aye.
Commissioner Montanez,
Aye.
Commissioner Ali Brown.
Aye.
Thank you.
Item number 15, calendar number 12314BZ, 855 Avenue of the Americas, Manhattan. Fried, Frank, Harris, Shriver, and Jacobson.
Motion to grant.
Chair Perlmutter,
Aye.
Vice Chair Hinkson,
Aye.
Commissioner Montanez,
Aye.
Commissioner Ali Brown.
Aye.
Item number 16, calendar number 14414BZ, 1751 Park Avenue, Manhattan. Sheldon Lobel.
Okay, we're going to reopen this hearing.
On a motion to reopen,
Motion to reopen.
Chair Perlmutter,
Aye.
Vice Chair Hinkson,
Aye.
Commissioner Montanez,
Aye.
Commissioner Ali Brown.
Aye.
Richard Rivera, Sheldon Bell, PC for the applicant. Good morning. So I've brought with me today Linda Rosenthal, who's the Assistant Executive Director of the Children's Learning Center, and Stephanie Huxermeyer, who is the project architect, as well as Chaim Babad, who is the building owner. So we were just hoping to have a conversation with the board about what we can do to finally move this application to completion. In our last submission, we gave the board a letter from a building security expert who has done building security in over 300 buildings in New York City. And this was evidence of the fact that we thought that the keyed entry system, which we were proposing, was going to be an effective entry system. The board did not view that as compelling. So in an effort to get beyond that, what we'd like to do is essentially talk to the board today and get an acceptable plan and an approval for what we can do to reclose the case and to bring this to a decision. I'd add that since the time that we saw the board, we've been in front of the community board who has voted overwhelmingly to approve this. We've been in front of Councilmember Inez Dickens, who basically has indicated her approval. The school, as represented by Linda here today, is very anxious to get in the space. As of, again, December 2014, we will be kicked out of our space on West 103rd Street. And so beyond December 31st, there will be no home for 90 disabled children, including some who are severely autistic. And I think it's in everyone's best interest to work towards that. I would have Stephanie come up for a moment, the project architect, as she has basically sketched out what we hope to be an acceptable solution. And to the extent that's acceptable to the board and the board, we can move forward on that. That would be wonderful for us.
Great, okay.
Please state your full name.
Stephanie Huxermeyer. I'm with Lee Brown O.C. of our architects. Basically what we've come up with is a plan for the lobby space that allows for 2 separate locked entries, one for the Bailey House program and one for the Leakin Watts School. We're leaving the glass curtain wall as it is on the exterior, so there would be a shared lobby space with a guard that is shared for both programs that then controls each locked door. So there's an added layer of security at the lobby. At the lobby space. That would require is for us to reconfigure the elevator to turn the door so that it's accessed separately from the Bailey House entry.
I'm sort of understanding this description, but you don't have a sketch of
I do have a sketch.
Could you pass it around or hold it up? Or
It's really a sketch.
It's actually on trace. Where'd you get that? So, you see. Got it. Okay. But what happens is all of the people from the street, so both the people who are using Bailey House and the children, are in a common lobby, right? And then they each enter their own elevator lobby.
Correct. So there's a security guard that's controlling that kind of common lobby space.
Right. So question, and I know the owner is here, so could probably respond better. The concern really was about the small children and their caregivers and adults who may not be having a good day being together in a confined space where the children are compromised. Mm-hmm. So this is actually confining their space even more as opposed to less, you know what I mean? Because for that moment, everyone's potentially in that now really tiny lobby together while they're waiting to be buzzed in or however it works, right? So what we had been talking about was a completely remote entrance where the Bailey House clientele go in through the lobby, that's the current lobby, or you could reduce the size of that lobby, and then there's a completely separate entrance from the street for the children. Mm-hmm. And since you're looking at reducing the size of the lobby significantly, I'm not sure if that's affecting fire egress, that might not actually be permitted. I'm not sure about that. But if you're willing to reduce the size of the main lobby, maybe there's a way to affect the curtain wall and put doors coming from the street into a lobby that's either increased in size because it goes straight into a lobby from where the commercial area is. That's the other thing. We don't understand what the use of that commercial area is. It's always shown as commercial. It's not shown as occupied, whereas the other is shown as a bakery. So I don't know about that. But that's really the goal. At this point, it's blending the two groups in a very tight confine. So I'm not seeing how that solves the problem.
So you're saying that you would prefer two separate, physically separate door entries from the street, even though those doors would be essentially right next to each other?
Well,
and then you would require two separate guard stations, or would one shared guard configuration still be appropriate?
The concern is really about the children. So the guard is most important to guard the children, right? To keep the children isolated from the adults who are coming into Bailey House. So so we're talking about separate entrance. I mean, the ideal solution is a remote entrance. Again, not knowing what the situation is with the commercial space, the ideal solution actually is like a single stop elevator that goes from the remote corner of the commercial space right up into the space for the children. But again, that's the ideal solution. Okay.
We were hoping to have Linda Rosenthal, the Assistant Executive Director, speak for a moment because this issue came up with the community board and there was actually some discussion about potential mixing of the populations.
Good morning, everybody. I just wanted to say that in terms of the student population, the children are between the ages of 3 and 5, and for each group of children there are a minimum of 3 adults. The classroom configuration is 3 adults with 6 children. So as the children are entering and exiting the building, they are escorted. The matron helps them off the bus, and then the staff escort the children into the building, into the elevator, up to the floor. So at no time are the children left alone, unescorted. So in terms of the separate entrances, that will help. But even if we were to have a single entrance, the children will always be in a staffing ratio of 3 adults, or 1 adult for every 2 children. So I hope that helps.
That we understood actually from the last hearing. The concern really, there's a few concerns. One is the particular type of clientele at Bailey House are, let's just say, people not having, not even just a good day, let's just say generally a good situation. And that we're concerned about the children being exposed to someone who is behaving in a way that's just not appropriate for small children to be exposed to, especially for any children, and especially children who are compromised themselves. And then, of course, there is so much press recently about children who are in some way disabled, who are disappearing from their place, their schools, and despite the number of caregivers and all of that, they managed to find their way out into the stairwell, into the lobby, into the elevator, who knows. And we just don't want to even think about what that could mean.
I certainly appreciate that. The exits on the second floor where the program would be located will be alarmed. So if anybody were to push the crash door, an alarm would go off immediately. But the children are even escorted to and from the bathroom. At no time is any child in the hall by themselves, and the classroom doors remain closed when the children are present in the building. So I just wanted you to know we're very careful about this. We have Department of Health, child care regulations, state education, and New York City Department of Ed regulations that we follow very closely.
Right, okay, I understand. Thank you.
Thank you.
Okay, and did you say you also had the owner here?
We do, to the extent you'd like to address any questions to him.
I mean, the questions are really to you and to your client's negotiation with the owner, because I understand that it's a tenant, but I think that the owner needs to hear from us that this is not an appropriate use until we separate children from adults in a 2 sets of compromised populations.
Sure.
Shouldn't be sharing a lobby together.
Yeah, I mean,
right?
I think that the discussion that we previously had with the school and with the community was that the population, the student population here, as Alan Mucatel, who is the executive director, has said in the past, these are one of the goals of the school is integration of this community, school community into the larger community. And so to say that, when they're outside the school, in the street or a moment before they enter the building, that there's some distinguishing factor between when they're outside those doors versus when they're inside those doors is, it's maybe a little bit overstating it. I think the fact that we are, first of all, I think we all have the same goal here, which is to establish a school in this location. And to the extent that they come into this space and then are in a secure environment, are escorted into a separate elevator where neither party has access to the other, and I really think we're working hard to try to do this. I think that, from a timing issue, we're coming up against a very hard deadline, and I think to the extent that we can satisfy the board on our submission to staff that this is a workable solution, at a minimum, we know that there are 2 secured doors, one for each of the elevators, and so, we would hope that the board in good faith can allow us to work with that.
So I understand what you're saying about the sidewalk. We can't control the sidewalk, right? This is not really an ideal situation kind of under any circumstances. I know the children are part of the world at large, but actually the world at large is not primarily made up of former substance abusers and former incarcerated individuals. And if they're sharing like this, their world at large will be. So the idea, and what's unfortunate about this is I wish we had known this earlier, so we could have handled this before we went to the last hearing. And in future, please include all the data that there is about a surrounding use that's relevant to in particular a school. So if we wanted to secure this like right away, if we could get the owner to just agree to this, I would say. And again, what's the use of the commercial space right now? Is it rented?
It is rented on the ground floor. I think there's a, it doesn't have anything.
Okay, so it's vacant, so it's perfect, okay. So I know that this reduces the amount of rental space, but if at the remote side, so that would be the northern side of the rental space, there was a lobby and a one-stop elevator that brought the children in, great solution.
I think that we understand. I think that in addition to the sketch which we have passed around, I think that to the extent we can separate those entrances, we'd like to do that.
Well, let's see what happens, okay? Because the one-stop elevator is a better solution. It would alleviate lots of.
Is that a new elevator?
That's a new elevator, but it only goes one stop.
Yeah, I would strongly request that the solution providing 2 elevators with a dedicated elevator as is currently configured to each be accepted by the board, considering the fact that that every single stakeholder here on this side has indicated that they want to move forward with this plan. Moreover,
stakeholder being the parents and children.
Being the school, the operator of the school, the community board, the council member, the owner of the building. There's been a unity and interest here, and so we would ask that the board strongly consider the latest configuration, segregating those entrances and allowing them to go. The installation of a new elevator here will absolutely be able to accomplish within our time frame. Moreover, when I do not know things about landscape architects, landscapes or planting, I consult a landscape architect. If I don't know something about building materials, I consult a building material specialist. We've consulted a security specialist here. We understand that this was not compelling to the board. However, the introduction of a new elevator here, I think, is going to really just is going to destroy the time frame here.
Time frame.
What?
But the installation of the elevator could be a condition to approval, to C of O.
I think that the addition of an entirely new elevator is beyond the scope of what should be reviewed here. We've devoted a single elevator to each of the uses, which cannot now. We will completely separate those populations entering the building. There will be no mixing whatsoever. I think that the addition of an elevator is really beyond the realm of what should be considered here.
Okay, but so what I'd like you to do is explain why that's true. It's not beyond the scope of the authority because you're asking for a special permit.
Correct.
The use has to be appropriate for the surrounding, the use has to be appropriate to the district, right?
Right.
And the children have to be appropriately protected within the domain. And
Chair,
so
the previous request was for separate entrances, correct?
the previous request was for separate entrances in a way that would protect the children. This sketch does not do that.
Right, but now we're going to be making separate entrances, which are entirely separate. The children will have, once they enter the building, will have no contact with the residents of the third and fourth
I'd
stories.
still like you to look at why a separate elevator would not be a viable solution. To just reject it out of hand, I'm not understanding.
We can submit documentation as to why that's not an acceptable solution.
Okay, and then it also show a sketch of an acceptable separate entrance, totally separate from the street.
Understood.
Okay.
Okay?
Yes. Any other comment?
Actually, if I can make one more statement on the record. During the executive session, the chair commented that you were not, quote, made aware of the use by the applicant of the third and fourth stories, and that we were, quote unquote, not forthcoming. In our statement of facts submitted June 20, 2013, we included a copy of the discussion of the city planning report detailing the occupancy of the third and fourth stories, which contains a detailed account of Bailey House, including the fact that it provides supportive housing and community services to men, women, and children living with HIV/AIDS. So I just think that
to clarify, it was missing the first page.
What?
The first page, the submission missed the first page of
Okay.
the report, and therefore there was no information, and without going ourselves to the city planning
Fine.
website.
So if there was an omission in that submission, we apologize, but we would never intend to in any way deceive the board about the use of the third and fourth stories here. Okay.
Are there any speakers on this item? Okay, how much time do you need?
We would request that the hearing be closed, that we submit plans demonstrating all of the options to the board, and that for a potential grant on October 7th.
On October what?
7th.
There isn't to submit on October 7th.
No, to submit on September 30th and to potentially have a closing grant.
October 7th.
Correct.
So you're going to be able to take a look at the one-stop elevator, come up with a cost analysis on a one-stop elevator and all of that's entailed, show a sketch of the one-stop elevator and explain what's wrong with that.
Right.
And what's wrong with that in addition to the costs, right?
Right.
And by the 30th.
Yeah.
For hearing on the 7th.
Yeah.
Okay, I would like all of the people who attended today, I'd like to have them attend the next time too, please, including the owner.
That's fine.
And also, I guess this goes without saying, but just to make sure that it's not just what the chair has said, but also give us, if in fact you can show that that one-stop elevator is not going to work for you, give us a viable solution that physically separates throughout the entire children's experience in the building.
Sure. I don't think it's so far
From
off.
their population.
Right. I don't think it's so far off what we've submitted today. I think it basically involves, further separation of those two entrances.
It probably involves a wall.
Correct. Or perhaps a glass partition.
Probably involves a wall.
I'm hoping the kids aren't strong enough to break through a glass partition.
No,
but
it has more to do with the exposure of the children to the compromised
Yeah.
people who come to this.
Okay. I think I'd also probably submit testimony.
You need to acknowledge that this is not, if these were your children, you'd probably pick a different school.
That is not necessarily the case. There are very few schools in Upper Manhattan which address severely autistic children, and when we were at the community board, we literally were answering questions of how many people could apply to this and whether it could be given to local community members. So I think that if I had a severely autistic child on the Upper West Side of Manhattan or in the Lower Bronx, I would be very anxious to get them in the school.
But did you explain to the community board who they're going to be hanging out with?
They absolutely know that. The community board is the same community board which approved the application for Bailey House, so they know very well. Okay? Thank you. Okay.
So submission on the 30th and the next hearing on the 7th, and we'll decide whether we can close and at that time.
Thank you, Madam Chair.
Oh, no, we're doing it after Winchester. Sorry, are we calling Winchester?
Continued hearings?
Yeah.
Item number
I think we decided to
17,
do that.
calendar numbers
Yeah.
7811BZ and 3312A through 3712A, 78-70 Winchester Boulevard, Queens, Sheldon Lobel.
Good afternoon, Jordan Mose from Sheldon Lobel on behalf of the applicant. So this matter has gone through several hearings and submission iterations, and as you're aware, is a significantly changed project from what it was when it originally came in, when originally filed. The project now, which is a variance application as well as a general city law section 36 application. And I have a revised site plan for the GCL application. I'd like to just hand up, just for reference purposes. I'll be making a formal and complete submission, and of course we'll copy all the parties on this material. I have additional copies that I can make available to others that are here. But we'll be sending, like I said, making an official submission with respect to it. The project now has been reduced from over 2 FAR to 0.8 FAR. Height been reduced from 97 feet to 43 feet. 2 buildings are now 1 building, and there are 57 units proposed on the site that originally called for 143. All the units that are proposed are also 1 and 2 bedroom units. There had been a number of larger square footage and larger bedroom count units. They're all now smaller 1 and 2 bedroom units. It is still proposed as senior housing, and well, we've gone through there's a whole number of factors that contribute to the special cost involved in developing this site, which are all enumerated in the engineer's report and in my statement of facts. Most notably are the introduction of significant amounts of infrastructure to the site, given the site's distance from those services. There was a question yesterday regarding what sort of accessory use might be that is indicated on the ground floor of the building. Those would be accessory uses to the, really to the ICCC, the types of, it would be relating to both the housing and the ICCC purpose. Community center, youth programs, counseling programs, cultural activities would be the types of uses that would be in those spaces and rooms located on the first floor.
So it's programmatic use for the community facility,
right,
not necessarily for residential purposes.
Correct, although I think they could be a medical room that could be related more toward the senior population. So that there's no, assisted living facilities don't fall neatly with it, which this is not, but those types of uses still are within use group 2 classification, since it's not a nursing home type use. So if those are accessory to the residential, I guess some of it could be
delineated what
we can delineate. We can try and delineate that.
Which use group it belonged to.
Okay, we can do that. I'd also like to point out that it's an unusually shaped site, and that the site, which has approximately 83,000 square feet of lot area, on which this building the proposed building would sit, is about a 17,000 square footprint, which is about 21% lot coverage, a fairly low lot coverage figure. Obviously, a great deal of the space on this site and the lot below is eaten up by roadways and access in order to accommodate fire department requirements. These plans that I've actually just handed up have not been delivered yet to the fire department. We're trying to get to a point where we felt that there was we'll be submitting it to the fire department. So, and I think that while this is a different building that the fire department hasn't seen, the architect and myself and the fire department sat down to discuss what sort of requirements they needed to see on there. And I think all of the items that are on the fire department checklist of roadway width and fire hydrants and access are all now shown on here.
You've removed the ability to circumvent the, circumnavigate the site with a 30-foot wide road. Do you believe that the fire department is not going to require that anymore?
I think so.
I
think
on your previous iterations.
On the previous one, I think it was it was also a narrow street. It was
a 30-foot wide
It was
road.
maybe 30 feet with no parking. So
Now it's 20 feet.
now it's 20 feet.
So just asking whether or not that was a fire department requirement. Now, the fire department only has access to the front of the building.
I think there was a portion, I don't have that plan in front of me, you may have it in front of you, but I think there was one of the roadways that was specifically shown as a non-fire department roadway like this,
But it allowed the fire department access to the rear of the
if they needed to get around. We'll find out if we need to make that change, we'll make that change. I mean, I know how that's,
I'm just bringing it to your attention
Thank
before
you.
you take it to the fire department.
right.
So the main ingress to the site and egress is through the Creedmoor roads and
Right, it's,
Second Avenue is only for emergency purposes?
well, no, it's through the Creedmoor roads, I think will be the primary, but 82nd was originally envisioned as only an emergency access route, but I don't know that it will be only an emergency access route, 82nd Avenue, because we never got the access that was originally sought to Union Turnpike.
This is not 30 feet. This roadway could potentially be 30 feet or wider.
Which roadway specifically?
Second Avenue, through the, you need an easement to get there.
Right, we have,
Will that road be 30 feet wide at a minimum?
the easement that's in place is, well, the easement, the red hatched roadway is not. You can see that blow-up of it shows it's got a 25-foot depth.
Okay, so it's only 25 feet.
And it's got an angle that is less than a 90, or it's greater than a 90-degree angle, so that may help facilitate access via a truck. That's what's shown there is like a truck radius diagram, I think is what's shown there in the green.
In the green, okay. And that roadway right now, there's a gate there?
There's a gate there that leads to that's a closed gate to the Feinstein Center that spans the whole roadway.
So that gate would have to be removed?
Will have to be modified. I think that point of access would be, we would try to split that access or push the Feinstein access just back to the top of that easement area, if you will. So they would still have the same type of access to that roadway, but we would have the access, but the ICCC would have the access they need along through that easement area.
And I'm just curious, how close is the nearest resident to that egress?
There's a house here at that corner at 82nd and 242.
Adjacent to the...
There may even be one, yeah, I don't know if there's one that's not on 242. No, I think, I'm sure I'll be corrected if I'm not correct, but I think there's one on the corner of 82nd and 242. I'm certain of that.
Okay, but not further into 82nd?
You mean just on 82nd? Yeah, I can, that's probably in my, probably can see that in a statement. I don't think so. Here. No, that's one, that looks like there's just, there's one lot there from 242 to the lot line. That would be with lot 500. I think so. I'm not sure. There may actually be another house farther in there. I'm not sure. I'm sure someone will correct me if I'm wrong. I'll let you know. If you want to see what's on that segment of 82nd.
What the conditions are right around the entrance, east coast on 82nd Avenue. So you're complying with most of the fire department requirements. They also wanted you to remove the lock gate at Winchester.
The what?
Remove the lock gate at Winchester Boulevard.
I don't know if there's a locked gate there.
Okay. That was one, and you needed, I guess, approval to obtain private water from the property. Is there private water supply on the property?
Well, there's no water supply on the property right now. You mean through the Creedmoor?
Mm-hmm.
I'll have to find out where water is going to come from.
Okay. So on lot 500, this three-story building B will be a complying building. What will that use
be? Building C and D would be residential buildings. They're both in the R32 zone.
Right, building B?
Building B would be more community, it would be community facility, which is the only use that would be useful to the ICCC that's permitted in that zone, because that's in the C8 zone. So it would be additional community facility space.
And what?
Again, for programs and meetings, and it could be senior-related space as well.
The landscaping details. You have grass areas, and in terms of the landscaping, you had at one point proposed about 400 trees, if I recall. I was just wondering if you have, substantial planting widths in order to fit whatever you were proposing, and if you could give us a little more.
We can give you a planting detail and a sort of a diagram of a typical planting area too.
And I did bring this up yesterday, and I see that you're still planning on having a pylon sign.
Yeah, I'm not sure.
I don't know where the pylon sign is, but it's on the, it's in the legend, so what is the meaning?
I will find out what that is. I'm not sure what that pylon sign is. And I don't know where it is on there, on the diagram. Why is that there?
Those are the questions I had. I think it's a much better proposal.
Thank you.
Are there any other comments on this? Are there any speakers on this item? Okay. Do we have an order of speakers? Maybe?
I don't have all of them. They just all get to sign in.
Okay, but maybe we could just do it like that, call, because it looks like there are a lot of speakers. It's a,
I don't have the opposition.
Oh, okay. So, okay, yes, sir. Oh, there's, oh, sorry.
Councilman Wolf. Thank you.
It's all right, yeah. Senator Tony Avella, in opposition to the application. She called me council member. She remembers how many times I've been here. And you'll see me a lot. Whether that's a good thing or not, I don't know. Good afternoon, Madam Chair and Commissioners. It's now afternoon. I submitted written testimony, but I have a few comments. The amended application before the board today was due to be filed on Tuesday, September 9th. Yet none of the interested parties received the amended application until Friday, September 12th, and most did not receive it until Monday, September 15th. Unfortunately, BSA denied the interested parties the community's request to have the hearing adjourned to the next available date and simply stated that the record will be kept open for additional statements to be received. While I appreciate BSA's willingness to keep the record open, I am deeply disturbed that after months of numerous 11th hour adjournments requested by the applicant, BSA could not see fit to give the community sufficient time to review a more than 100-page amended application, including extensive financial statements, and to prepare a detailed oral testimony to be delivered here before you today. Nonetheless, we have attempted to do so, and I join with them in their reasoned opposition to the amended application. I will only add a few additional comments set forth below in relation to the applicant's conduct and their, quote, programmatic needs, end quote. I continue to maintain that the historical conduct of the applicant must be a significant factor in BSA's consideration of the variance and GCL waiver under review. In the current amended application, the ICCC continues to include the same false and misleading information that has been a part of their application since the first filings well over a year ago. This continued attempt to use fraudulent and misleading information only adds to the severe lack of credibility of the IDC, which BSA must consider in reviewing this application. I refer you to my previous written testimony, which highlights the fraudulent and misleading statements found by the New York State Inspector General and direct contradictions to many of the ICCC's statements of facts and findings, including the alleged support being offered to the ICCC by such organizations as Catholic Charities. In the last hearing in February 2014, there were several pointed questions put forth by the board members regarding the ICCC's programmatic needs, which are fundamental issues BSA must consider in granting any variance. I would like to remind the board of my previous testimony in September 2013 and February 2014, where I stated that the applicant was able to purchase public land from the state at a significantly reduced rate, specifically because of the unique physical conditions of the property. Furthermore, the applicant manipulated the sale price by purposely deceiving their own appraiser, who stated that the highest and best use of the property was a community center, by failing to disclose their intention to develop some sort of residential housing on the property. In addition, the applicant spent a decade working behind the scenes to obtain ownership of this property under the false pretense that their single objective was to build a single-story cultural and community center. It was this purposeful misinformation that state legislators relied upon when they authorized the sale of this public land by passing legislation in 2006 to authorize the sale of state-owned land for the express purpose of allowing for the creation of an Indian American community center to be established on a portion of Creedmoor property. All of these facts are relevant to BSA's consideration of granting the least variance necessary to enable the ICCC to fulfill its programmatic needs. I vehemently oppose any suggestion from the IDC that there was a mandate from the state legislature that this property be used for senior housing. The only mandate inherent of the sale of state land was that the property be used for an Indian American cultural center, community center. Therefore, BSA must consider that the program needs now being put forth by the ICCC bear no relation to the programming needs that they put forth to ensure their ability to obtain prime public land at a significantly discounted price. The fact that the ICCC was able to get language in the deed of the property allowing them to build, quote, senior housing, end quote, cannot be interpreted to alter their fundamental programmatic needs in building and operating a cultural and community center. To do so would set a dangerous precedent in allowing applicants like the ICCC to fraudulently obtain an unwarranted exception to the zoning law and promote abuse of the BSA's variance granting authority. Based upon the foregoing facts, I respectfully request that this variance be denied in its entirety. I also respectfully reserve the right to provide BSA with additional testimony, given the lack of sufficient time given to the community, to review ICCC's amended application dated September 9, 2014, prior to today's hearing. Thank you.
Thank you. Next speaker. Yeah.
Thank you. My name is Bob Friedrich, and I'm the President and Chief Financial Officer of Glen Oaks Village, a co-op of 3,000 families. It's the largest garden apartment co-op in New York, and it's less than 1 mile from the applicant's proposed building. Glen Oaks Village is truly an affordable community for both young and old, and I submit this testimony in opposition to the ICCC's amended application. The financials presented by the ICCC are seriously flawed and wholly insufficient to entice legitimate investor or banking interest to put up the necessary capital to finance this project. The ICCC's operating expense projections are seriously understated. The financials provide no evidence to show that private or government financing is in place or even possible. When realistic costs are imputed, the rate of return calculations are negative, negating any possibility of legitimate investor or banking interest. This project has been represented as an affordable senior housing to be financed by the private sector. But yet, in the ICCC's own filing on page 10, under the affordable housing component, it states that the affordable housing component has been abandoned, and then readily admits that the project will not generate enough revenue or return on investment to garner private financing. The ICCC has no history of income production and has depleted its initial reserves, which came from investors in its subvention, as discussed in the IG's report, many of whom think they have first rights to apartments based on representations made to them by the ICCC. The only way this project could be funded is through the private sale of these residential units to the individual investors who've already put up money in return for a promise of a unit. This conclusion comes from the ICCC's own filing, which states, and I quote, "To the extent economically feasible, the ICCC will focus on certain forms of unit ownership and programs for unit resale that will promote affordability." Slick language that essentially means these units will be sold to these private investors who will then resell them or sublet them in co-op or condo ownership form. There is simply no other means in which this project could be funded through legitimate banking or investor resources. When unmasked, it is nothing more than a subterfuge to enrich a few investors who are out of pocket currently tens of thousands of dollars and have no other means to make themselves whole. It is a for-profit housing deal, not an affordable senior residence as represented to the BSA. It is an inappropriate private investment for the benefit of a few on formerly public land, obtained at a significant discount based on a pattern of misrepresentations as acknowledged in the Inspector General's report. It is detrimental to the public welfare and should be rejected. Thank you.
Next speaker.
Please state your name for the record. You'll be given 3 minutes, starting now.
Good afternoon, Madam Chair and Commissioners. My name is Richard Hellenbrecht. I'm a resident of Belrose for the past 4 decades and very active in civic affairs there. I am Land Use Chair of Community Board 13 and President of Queens Civic Congress. I have been involved in the Indian Cultural Community Center issue since the group's original approach to civic associations locally about a decade ago, when I was chair of Community Board 13. I have seen the ICCC's initial plan and every public plan since then. You must have heard that ICCC sought and won community approval by claiming to plan a single-story community center, some parking, and an athletic field. Our city and state legislators at the time supported that and supported legislation on that basis. Our city and state what followed has been fully investigated by the New York State Inspector General, which determined that the organization used deceptive and underhanded practices. These practices by the ICCC were very disturbing. But more important to the members of the surrounding neighborhood are the zoning implications. Should the board allow a 4-story building that is so massively out of character with the R2 zone nearby, other developers will feel empowered to seek property on the underused campus for similar development. This is a nightmare for the civics who have worked for decades with our representatives to get appropriate zoning to preserve the single-family neighborhood. Bernard Feinstein Developmental Center occupies a large lot adjacent to the ICCC's property. Bernard Feinstein came forward to the community with a reasonable plan to appropriately house, educate, and entertain mentally ill clients. As a result, the size and scale of the residential community buildings are in harmony with the surrounding homes. Feinstein even entered into an agreement with the local community leaders to use 82nd Avenue exclusively for emergency responders. This relates to our serious concern about the GCL 36 waiver. Whatever project is approved for ICCC must abide by Bernard Feinstein's 82nd Avenue closure. We are seriously concerned that for the safety and well-being of consumers of these programs. Consumers are quite accustomed to walking around the campus with little regard to traffic. They may at times be medicated. Increased traffic by seniors and visitors on poorly marked and badly maintained campus grid roadways could be catastrophic. Also, ICCC's roadway narrows to only 20 feet wide, generating concern for emergency access by fire apparatus, ambulances, and police. The ICCC property continues beyond this building lot. They also own an adjacent lot, number 500, which is zoned R32. A drawing was presented to Community Board 13 showing a row house development there. In reviewing the present proposal, the board must be aware of exactly what is planned there and how it will affect the access and egress to the site and additional impacts on the campus.
Your 2 minutes is up, so please wrap up quickly.
Okay. Finally, the board must take into consideration the organization's financial and human capital, its experience and credentials to execute and operate a development of 57 units. Seniors have special needs, but there is little planning, professional assistance, and appropriate facilities. I do hope that you will side with the community and keep this project scaled down.
Thank you.
Thank you.
Next speaker, please. Please hold your comments to the 3-minute limit. There are a lot of speakers.
I'll try. Good afternoon, Madam Commissioner and board members. My name is Jerry Wind. I am president of the Belrose Hillside Civic Association and executive secretary of Community Board 13 in Queens. Our homes are directly adjacent to the proposed ICCC project. At the last public hearing on February 25, 2014, the former chair of the board addressed the ICCC's attorney, Mr. Most, stating that their submission for permission to build 2 6-story buildings was out of character with the surrounding community, and directed them to come back with a project that was. Their current submission of a single 4-story building with rooftop recreation area does not satisfy the board's mandate, as our community consists of 1- and 2-family homes, which do not exceed 2 stories. Due to the building's height, close proximity, and the removal of the existing trees to accommodate the proposed roadway, the homes on the Cross Island Parkway and 242nd Street would be severely compromised. In the ICCC's revised statement of facts and findings on page 7, it states, and I quote, "The Feinstein Center gate and point of emergency access at 82nd Avenue appears to encroach on the ICCC's easement rights. Has a survey been done to substantiate this claim? The easement diagram at the bottom of the same page does not accurately reflect what is actually there. At the last hearing, I submitted a photo of that area. Do they have permission from the state to use the existing Creedmoor roads? 242nd Street and 243rd Street, the area's only arterial streets, are narrow and cannot handle the additional vehicular traffic that a project of this scope would generate. I wish to make it perfectly clear that our community supports true senior housing as long as it fits the character of the community. This is evidenced by the fact that several years ago, we supported Catholic Charities' acquisition of Creedmoor property to build the Father Reader apartments on Hillside Avenue. This development is all one-story structures and is populated entirely by seniors. The ICCC project permits seniors and their dependents to occupy an apartment. What happens if the senior passes away and the dependents are not seniors? Are the dependents made to leave? Since the senior is investing in this apartment, what happens to his investment? We are also concerned about the financing for this project. The ICCC has not been forthcoming on how this project will be financed. Okay? And basically, we don't want a skeleton to be left there to rust. Thank you very much for your time.
Thank you. Next speaker.
My name is Michael O'Keefe. I am the president of the Creedmoor Civic Association. On behalf of the Creedmoor Civic Association, I testify in opposition to the variances requested by the Indian Cultural and Community Center. In the time allotted, I will focus on a few items. In conjunction with other neighborhood civic associations, the Creedmoor Civic Association will submit in writing a more detailed community opposition statement. We recognize that the size and scale of the project has been diminished. However, we believe that the current proposal would harm the quality of life of neighbors in the immediate vicinity, some as close as 60 feet away. The 4-story, 220 by 114-foot building would tower over surrounding 1- and 2-story homes. Lack of trees, many balconies, and rooftop recreation create an infringement on neighbors' privacy. Another issue to consider is that New York State seems to be in the process of divesting itself of many land parcels on the Creedmoor campus. This building would set a precedent that would allow other developers to build similar size or larger buildings not in character with the surrounding R2A zone. Up until now, new development on the Creedmoor campus, which is R32, has consisted of 2-story Country Point homes and the 1-story Father Reader retirement housing, which are compatible with the community. Belrose and other surrounding communities have recently been downzoned because city planning and local elected officials recognize the need to protect the character and density of the neighborhoods. Financial considerations will be covered in greater detail by other speakers and in the written submission. The analysis by Daniel P. Lane and Associates, page 4, shows that owner investment of more than $25 million with financing of more than $16 million and an equity of more than $8 million. This would make the average unit cost over $400,000, not including operating costs. Financial records indicate that the ICCC has limited or negative net worth. To my knowledge, the ICCC has not demonstrated where the necessary financial resources would come from, especially for a down payment. It would be detrimental to have a skeleton that was an unfinished building in the community. And the last concern has been discussed, the GCL waiver. And I know you just received a new plot plan, but when this was written, we did not have any information on the on lot 500, and we had concerns about whether that would provide adequate egress, depending upon what was proposed there. And finally, the 20-foot lane around the building has been dealt with. So we request that the board consider these issues when making their decision. And I thank you for your time.
My name is Frank Toner. I'm the president of the Rocky Hill Civic Association. Madam Chair, Commissioners, I testify today in opposition to the requested variance for the Indian Cultural Community Center Incorporated, the ICCC, which proposes the construction of one mixed-use building containing residential units and community facility uses at 7870 Winchester Boulevard in Queens. I note that since the last time I testified, the proposal has changed from 6-story construction of 2 buildings to erecting one 4-story building. The change has not affected my opposition. I wish to note that my remarks will be short, since I have signed on to fully support the community opposition letter that Richard Hellenbrecht will submit. That document gives in-depth reasons for objections as a community. I am president of the Rocky Hill Civic Association, which borders on the grounds of Creedmoor, on the other end from where the facility is being built. In all my years as president, there has not been another issue that my community has opposed so strongly. In my civic and other nearby civics, well over 1,000 petitions were signed against this project. The reason is that it is out of character with the housing in our community. There are 2 developments that happened on the Creedmoor grounds in recent memory. The 1-story Father Reader senior housing and the 2 family units of the Country Point land. Both developments have easy access onto major roads. A 4-story building with walled-in recreation area on top would loom over the nearby homes. The only community support I see for this is when I have heard the opposition testify at these meetings. When I met with members of the ICCC years ago, I expressed to them my belief that the community only wanted housing that is contextual with the neighborhood. I pointed out at that time the Father Reader homes that had been built on the Creedmoor campus. Finally, I expressed my concern about the ability of the ICCC to erect and manage this facility. This is a group that years ago told elected officials they wanted the land to build a community center. They then slipped the words residential building into the deed. They then said they needed to build 9-story buildings in order to be financially feasible. Then they said 6 stories would do the trick. Finally, they say that they can be viable with only a 4-story building. This is a group with no significant experience and no obvious resources. The last thing my community needs is a half-built building laying there rusting. Thank you very much.
Good afternoon. I think I'm going to be the last opposition speaker. My name is Mitch Ross. I'm counsel to the civics and the community in opposition here. I'm going to be brief because I'm going to be briefing a few issues with the board and its mission or testifying at the next hearing if you keep the record open. As I see the case, this is boiling down to really the C finding and the E finding. The board has to ask itself, whether the applicant has really met the E finding and whether the owner can make a greater effort to provide what might be a very well-intentioned senior housing development in a more neighborhood-friendly shape or form. Looking at this quickly, for example, there could be a 2 to 3 family detached, semi-detached townhouse type development that might provide about the same number of units and perhaps at a lower cost because they would be frame construction as opposed to what is being now proposed with this 4-story building, for example. And I hope the board would ask the applicant to at least investigate that. Because, it really shouldn't be the role of the community, although it has been in this case, to show the ICC or help them to discover little by little how they can fulfill their needs, their programmatic needs, with progressively smaller and smaller developments proposed to this board. As many of the opposition speakers have said, initially there was proposing a 16-story building, then a 9-story building, 2 6-story buildings, and now a 4-story building. It's great. It's going in the right direction. We need it to go some more in order for it really to not affect the adjoining properties adversely in the character and future development of the neighborhood. I also question whether or not this is a programmatic needs case. Senior housing isn't a defined term. It's not primarily a community facility. I know there's been talk that that's what was intended here. So I'm not certain whether or not the board even needs to consider that need and in any deference to this organization when really what we're talking about is a straight use group 2 housing development. So, on that note, I want to thank the board. I understand that the applicant's attorney has done an excellent job in trying to sort of rope in an owner. I'll just be one more minute. An owner that has really proposed some outlandish things here. So I hope the board will look very closely at this and give us an opportunity to respond to anything else that's submitted. Thank you.
Good afternoon, Madam Chair, Commissioners. My name is John Borkey, and I speak on behalf of ICCC. We have heard a lot of statements against this four-story building that was proposed, saying that it will be out of character of the neighborhood. Let's look at the neighborhood that they are proposing to build. The area is very much a neglected, rundown, industrial piece of land. To the north, the main Creedmoor Hospital is staying there with its 22-story building. To the west and south, there are taller buildings scattered all around and was abandoned. These buildings include a 10-story garage, large active salt dome, and a 10-story power plant, and 2 white smoke stacks that are about 18 stories tall. To the east are a few homes, and immediately after that, it is Cross Island Parkway. Also, the property is below 10 feet street level. Right now, this place is filled with growing plants and creepers. And there are also abandoned buildings, and the housing is more or less covered with bushes, and raccoons and other imminent dangers are there. By creating a senior housing there, the area will be cleaner and have lots of green spaces. It will definitely improve the area, and the property value will go up. There are many benefits by giving variance to this. It will provide immediate construction jobs, bridging and assimilating different groups and cultures and neighborhoods. Most of all, we need a place for our seniors. We can build this facility and we can finance it. We have the experience and we have the expertise to do that. Let me conclude with this. I heard a lot of people coming over here, those interest groups coming out against this 4-story platform, 4-story building. They are saying it is out of character, it will bring more traffic, and they are all against it. The motivation is, it lies somewhere else. I will tell you this, I will stop. We are not asking anything beyond the limit of the law here. The land was purchased legally, and I tell you, if we can do it within the limit of the law, please do it. And I humbly do beseech you to do that. Thank you and God bless you.
Thank you.
Good morning, Commissioners. My name is Abraham Tai. I say Abraham, but I'm not the one in the Bible, so please, if you have any grudge, don't look for me. I'm standing here this morning just in support of ICCC's intention to have a senior housing and a community center. Because I live in the Bronx, in the South Bronx, Hunts Point area. I know what senior citizens need. We all, if you look at this room, you can see that our air is turning gray or getting colored. I work in a drugstore for 25 years. We deal with Casa Boricua. We deal with Aldous Green 980 senior citizen housing. We deal with 887 Southern Boulevard, Emma Carver, senior citizen housing. I'll give you 2 examples of 2 ladies. One called Borrero, Obdulia. She lived in a PH house. Her family happened to travel. She was left by herself in the house. And it happened to be that a man lived in 754 Costa Street, which is a senior citizen house. He came. And since I did not see that lady for like 2 weeks, I asked him to go and look. He went and knocked at the door. Guess what? The mother passed away for over 3 days. You guys can look at it. It came on the news 4 years ago. Another example I'm going to give you is Miss Josephine Villar. She lived in 980 Aldous. But since there was an interaction among the tenants and the people that lived there, one lady saw her in the hall and she said, "No, I see that your mouth is being twisted." And she called the other neighbor. It happened to be that on the same floor, there was a retired nurse. What she went and saw, she just called 911 immediately, and the lady was saved. So here, I'm not here to bash anybody. You are political, you are civil, we all going the same way. Either it's death or we save ourselves. So kindly think about it, and whatever you can do to compromise and help our seniors, because today is somebody else, but tomorrow it can be you. Thank you.
Madam Chair, Honorable Commissioners, and BSS staff. I'm here to support the project proposed by ICCC, and I had written a little bit about the location and the surroundings. Since my previous speaker went through it, I'm not going to read about it. Only thing I want to point out is that ICC building is not in the middle of any single family homes. This is a commercial area. The character with the nearby buildings are commercial. This is within the hospital complex. If you look at the full circle, how the property is by looking at 360 degrees, only less than 50% is near private homes. The mayor already said that we need more than 200,000 units of housing to keep New York City's population. However, we can reject this or against this proposal and say that we are supporting the mayor's proposal. More seniors live here in Queens than anywhere else in New York City. We need a place for them. We need to take care of our seniors. Please vote for this ICC proposal. We need more senior housing. Thank you.
Good afternoon. My name is Jaswin Samuel. I support ICCC Senior Housing Project. Good afternoon, Chairwoman, Perimeter, Commissioners, and BSA staff. I am here to support the Senior Housing and Community Center for GCL and variance for a 4-story building. The Queens Borough President Master Plan of 1999 and the Civic Congress Master Plan strongly recommended senior housing. There are more than 13 references are made in these master plans for senior housing. State granted permission for a senior housing in the deed. By granting the variance, the BSA is fulfilling the wishes of the Creedmoor Master Plan set forth in the original documents. The question is for you, what is better, Do you want a commercial complex or do you want a senior housing? Do you want a garage or a maintenance yard, or do you want a senior housing that benefit the community? What is the best interest of this neighborhood? Please make a right decision. Please help seniors. We are the community. We have lived here our whole lives and we served. The most people for this ICCC members came from India in 1970s and they lived here, served this country. They spend all of their good time here and most of them are retired. They want to live in a dignified, a good place for seniors living together, help each other. They like to live and lead their remaining part of their life in this area where they worked and they served this country. This is a democratic country. We believe the justice system in the United States is the best. We believe we will get justice. We got this land legally and we doing all these things, all legal means. So we expect, dear commissioners, members, give justice and don't hear the voices of the area real estate tycoons and some political interest. The politicians want to downgrade our community. So please give permission to build a 4-story building because the surrounding area is not all 2-story or 3-story building. All area around the north side of this road is 20-25-story Creedmoor Center, and surrounding only one side is a residential area. 3 side all commercial area. This is an abandoned area. So if there is a development, more people get jobs, more development. This is all abandoned place. All the animals, raccoons, everybody is roaming that place. So please make, this is a beautiful area for senior citizens, beautiful area where they can live the rest of their life. Thank you very much.
Thank you.
Good afternoon, Rosemary Leisky. I want to invite all of you over to 242nd Street and 82nd Avenue. I would really like you to see what my front window is going to look like. So anytime you can call me, I will take you on a tour. Okay, we are not against senior housing. Matter of fact, I am a senior. What we are against is about 4-story rooftop recreation area. We were told it was going to be a community center, a baseball field, and a parking lot. What happened to this plan? It might be 9 feet below street level on Union Turnpike, but when you come down to 42nd Street, where my house is, it will be street level. This land is across the street from my home. I will be looking into their windows, and their patios will be looking right into my front windows. I've had construction on the property behind my home for over 3.5 years. I really haven't slept. 43rd Street has 2 new home constructions being built. Now you want me to put up more construction? When is this going to stop? Belrose is becoming one big construction site. They say it is a nonprofit. Well, as I believe, and I was told, nonprofit is a 501c3. So does this mean that this community will be not paying taxes into the community? If so, how is this supposed to support my community? Where are the communities supposed to get money to help support what's going on around here? What this looks like to us is a co-op or a condo. Senior housing, as I know of it, is 52 and above, which I am moving into. This housing, we are told that children, the whole family can move in with their children. I don't think a 90-year-old person wants children running up and down the hall and having bikes in the hallway to be tripped over. To be
I'm sorry, please shut off any cell phones. Thank you. I'm sorry, continue.
When this first proposal first came about, I asked them, I said, oh wow, my dad's a senior. Can I get an apartment there? They said, I don't think you'll be able to. Why? I don't understand. This site has no roads to get into. They want to open up 82nd Avenue, which is our safe haven for our children. It is a dead-end street. We have a basketball hoop there, and at any given time, you can go down there and see children playing there. The closest park is on the other side of Hillside Avenue and about 6 blocks down. We have no place for our children to play except there. And when it rains, that whole area, 82nd Avenue, floods. You can't park it's known not to park your car there because it will flood your car up to the door levels. 57 apartments, 75 parking spots. As I know, most families has 2 or 3 cars. Where are the rest of the families going to park? 242nd Street, you cannot get down it. It takes... When you're driving down, you have to pull over if another car is coming at you. That's how narrow this street is. And when it snows, you really can't get down this street. Like I said, if you would like to come and visit us, we are more than happy. All the tenants will show you. And last but not least, a woman came up to me and asked me, how do I get back my $40,000 because I invested in an apartment in this project. Thank you very much.
Good afternoon. My name's Valerie Lang. I live in the shadow